And I'm going to share my screen. And as you guys know, we are in the throes of our offer to purchase and contract. We've been through a good chunk of it. We still have a little bit more to go through. I know this isn't the most exciting thing in the whole wide world, but I also hope we can see the benefit of going through this, not just here in post licensing because you have to, but also to continue to go through it as part of your business, to be familiar with what's in here, so you know how to best serve and protect your buyers and sellers. So when we went through, super quick recap, the first thing we did, we spend the first 2.5 pages defining things. And sometimes questions come up like when is the due diligence due? When is the earnest money due? Who is the escrow agent? How do I know when we went under contract? Remember, the number one question, whenever you look at the sales contract, whenever you talk to buyers and sellers about the terms of their agreement, the number one question you should always be asking yourself is, what does the contract say? And you may or may not know the answer right away, but if we're familiar with it, at least know where to go to find it, then we know we can find that answer. Guys, remember, this is the legally binding agreement between the buyer and the seller, the parties to the agreement. So we want to make sure all parts of agreement have made it to the contract. Anything that they've discussed, anything that they have come to terms, everything needs to be in here or one of the addenda or a party or attorney drafted addenda, which we'll see in just a second. So terms and definitions, we define things such as the seller, the buyer, the property. We define the purchase price, not just what is the purchase price, but what happens if any deposits or fees are made. How is that going to affect the purchase price? What is the balance due now that we've put down some fees and deposits? And again, making sure that we are referencing the applicable addenda per situation. So the contract lets us know if there's going to be a building deposit, that building deposit will be in accordance with the new construction addendum, a form that we will look at this week. You can see seller financing, loan assumption. Again, pointing us in the right direction so we know where to go to get the applicable addenda for this situation. Question comes up a lot. Y'all, I see this on our closed Facebook group. I see this in the legal Q&A. I see this a lot. The due diligence wasn't delivered. Do we have a contract? The earnest money wasn't delivered on time. Do we have a contract? And the simple answer to that is, what do y'all think?
What does the contract say?
Yeah, what does the contract say? That's it. So do we have a contract if the buyer fails to deliver the due diligence? Yeah, because contract formation has nothing to do with payment of due diligence fee or payment of earnest money deposit. Failure to pay either one does not mean, it does not by any means invalidate the contract. Failure to make the payment on time enacts this piece where the buyer shall have one banking day after written notice to deliver those readily available funds. We're under contract. It's just that the buyer hasn't done what they've promised to do. So the seller gives them written notice. They have one banking day. If it still doesn't happen, then it goes on to say that the seller shall have the right to terminate. So many people on Facebook, they didn't deliver, this contract's terminated. Disciplinary actions, you guys. So know that we're good. The money doesn't make or break the validity of the contract. The money is only a piece of the contract. It might be, and I see this a lot, it might be that the parties negotiate due diligence. They have something in the due diligence field, but maybe for earnest money, we don't do any earnest money. Maybe it's just due diligence. Maybe it's just earnest money and no due diligence. Maybe it's both. There's no wrong way to do that as long as the parties agree. And if the parties agree to X amount of due diligence, I'm just making numbers up. If the parties agree to X amount of due diligence, but no earnest money, then that's the agreement that the parties have. The lack of earnest money didn't terminate or invalidate the contract. So again, what does the contract say? If they're not due by their dates, or if they're dishonored, sometimes these checks bounce. I'd have questions for my buyers. How about you? If their checks bounce, I'd want to be sure that we were good moving forward. And again, when is all this stuff due? How do we know what this is due? Well, like Kara just said, what does the contract say? Payable and delivered on the effective date. Payable and delivered within 5 days of the effective date. So the contract tells us these things so we know how to proceed. Any thoughts or comments about the purchase price, due diligence, earnest money, those payments? We define earnest money. We're going to talk a little bit more about earnest money. We defined who the escrow agent is, so we know who is that impartial third party that's going to hold that earnest money on behalf of the buyer or seller and seller. We define the effective date. We define due diligence. We talked a little bit more about that due diligence fee and what it's for. All it's for is the buyer's right to terminate, specifically for any reason or no reason during the due diligence period. Again, so many times, especially sellers, get upset because the buyer wakes up or the buyer decides they don't want to purchase this property. And the sellers, I need to know why. Well, the buyers don't have to tell them. They can if they want to, but they don't have to tell them. All they have to do is decide, I don't want to buy this house. Excuse me. I had an agent, buyers terminated once during due diligence. Why? Because they went back to the property after we went under contract and they discovered that the sun set in the back deck, the back porch. They said, you know what? We like to grill out in the evenings. We like to be outside in the evenings. And if the sun's setting on us, it's going to be too hot and we don't want it. So they terminated. Is that a reason? You know what? To them it was. And what did they do? They exercised their right to terminate. Any reason or no reason. You know what the agent did after that? She got herself a compass. So every time she was with those buyers and they were in the backyard, we could see north, south, east, and west. So we didn't have to go through that again. She discovered that it was something that was important to them. And so now it became important to her. Does that make sense? Sometimes people just wake up and say, nah, I don't want to buy this house. And under that due diligence period, that's what they have the right to do. You guys remember caveat emptor? What's caveat emptor mean?
Let the buyer beware.
Buyer beware, buyer beware. That's North Carolina. That's how we roll here. We are a caveat emptor state. The due diligence period is, let's think of it as kind of sort of the buyer's opportunity to learn about the property. If the seller doesn't have to tell you anything, don't you want an opportunity to discover on your own? And that's what this is about. The due diligence period, let's call it an easy out. Yes, it costs money, but it's your easy out should you choose not to buy. So the due diligence period, we have to specify. And then we're getting closer and closer to settlement and closing. Again, we define the difference between the two, what we're attending, what we're agreeing on the date of settlement. Once we all leave settlement, that's when the attorney proceeds with closing. With the very last act being number 4 there, recordation in the appropriate county register of deed and deed of trust, if any, which shall take place as soon as reasonably possible after settlement. Then and only then, you guys, we're going to see this in just a minute. The contract says that the buyer should not get access to the property until closing. So the contract defines what closing is. So we know what that opportunity. Then we talked about fixtures and personal property. Again, the best advice I have to offer you guys is be very specific. Don't leave anything up for questioning, right? If you say the refrigerator, The seller could leave you exactly that. If you say, for repair requests, if you say fix the electrical, well, what does that mean? What exactly is it in the electrical that you want fixed? So be specific. Don't assume that anybody knows what you're talking about. And then we got into conversations specifically about the buyer. So you may want to make a note. Provisions 4, 5, and 6 are all about the buyer. So when you're working with buyer, you can point these out and say, this is for you. These are your discussions. 4, 5, and 6 are about the buyers, which means 7 and 8 is all about the sellers, listing agents. So you may want to help the parties pinpoint where it is that they want to look. I'm telling y'all right now, they are not reading this thing. Buyers and sellers are not reading this before they sign it. But I can still do my duty to encourage them to look it over, to encourage them to look it over before contract formation, before we even write up the offer, so they can know what it is, know what the terms are before we write it up. So 4, we went all through the buyer's due diligence, giving them a laundry list of items, starting with a laundry list of items that they should or should not consider inspecting. Of course, the loan is the biggest part of the process, but the property investigation. And guys, remember, this is the buyer's show. So if they want to investigate something, please don't pull out the contract and say, well, it's not on this list, so you can't investigate it. If this is something they want to inspect or investigate, then our answer is okie doke, let's do it. Because remember, they're the one buying this house. They're the one taking on, in some cases, a 30-year loan commitment, not me. What's my opinion matter with buying this house? Zero, zip and zilch, absolutely nothing. So anything they want, maybe they want to have mom and dad come over. Maybe they want to, come over one day and hold up paint samples. Maybe they want to measure the living room to see where their couch would fit. Whenever they want to get in the home, then we are going to schedule that. We are going to coordinate that with the seller and the listing agent to get them in the home, being mindful and respectful of the fact if the seller's still living there. So let's try to consolidate our visits, right? But we do want to get the buyer in a few times during due diligence. I don't know, you guys, I think Karen Jeffries bought a house. I'm not sure if Gabe has or not, but when I was buying, not yet, when I was buying houses as the buyer, when I walk in the door, I have these rose-colored glasses on, and I'm just looking at the home like, how can I see my family in this space? Can I see us living here? The first time the buyers see the home, they're not looking for the problems, and that's why they have us. Do I see things that cause a little red flag to go up? They're looking at their family dynamics and how they may fit under the roof. I can help them by looking at the ceiling for stains, looking for cracks, things in the floor, whatever may cause a flag for me to go up. Help them see things that they're not seeing. And yeah, whatever they want. I've not experienced it, but I have had a couple agents in my past that have had buyers. After we go under contract, the buyers want to have the priest come over to check the vibes in the home, to check the juju, if you will. Is that the buyer's right? If that's something they want to have investigated, what are we going to say? Oh, don't worry about it. I'm sure it's not haunted. And if it is, then they won't get you. No big deal. Is that what y'all are really going to tell your buyers? Are you saying?
I didn't tell them my house was haunted when I sold it.
Are you
I
going to
saw
say,
it.
when's good for the priest? I don't know. Jeffrey, you said yours was haunted when you sold it, so you lived there, right? I mean,
y'all don't think I'm crazy. I walked. I was in my bedroom and I heard something in my living room, and I went down there, and I can see it to this day. This figure that was in that room. I mean, I saw it. It was there, but I never brought it up when I was selling the house.
I was going to ask, because in North Carolina we don't have to, do we?
Let the buyer beware. So
buyer beware.
I'll say, Indian graveyard.
Yeah, I've shown 2 properties in my life that I've walked in the front door, and those teeny tiny hairs on the back of your neck, mine stood straight up, and I'm like, something in this house, something in this house. I couldn't get out of those houses fast enough. And I'm cool. I made it. I survived. But there's something to be said for vibes and energy, and call it what you will. If it's something the buyer wants investigated, we say, when's good for the priest? When is convenient for the priest?
I didn't get a priest. I'm Southern Baptist, so you know.
Let's see, sell or sale of existing property. Again, we are just, remember, this is during what the buyer should consider doing during due diligence. So all we're doing here is letting the buyer know, hey, if you have to sell or lease an existing property, then we encourage you to close on it or be reasonably sure that it will close by the time we're out of due diligence. Repair improvement says that very important sentence in this contract. The property is being sold in its current condition. Isn't that telling us it's just as is? The seller doesn't have to do any repairs. Guys, we can ask buyer's agents. If your buyer wants you to ask, isn't that our responsibility? Please don't look at them and say, well, it says as is, so I know they're not going to do anything. We can tell them it says as is and what we think that means, but does that negate me from asking? If that's what my buyer client wants me to do, even after my conversation, I work for them, don't I? I don't work for the seller in this case.
This right here kind of goes along with your story last week about, the picture coming down and there was a hole in the wall. Okay. Now, granted, the seller probably knew that hole was in the wall. Okay.
Mm-hmm.
We both know this, right?
That's why they put a picture there. Yep.
Yeah. So I'm selling my house. Now, keep in mind, this happened a long time ago. Let the buyer beware. And something that I didn't know was there until I moved the furniture out of the house. And I freaked out when I saw it. Now, my home was inspected and it passed everything.
Mm-hmm.
But now I'm moving out of the house. Now, let's all be honest about something. How many of you have got a rug in your house, one of those, like, I don't know, 8 by 12 or 8 by 10, those heavy rugs, and you have stuff
Big area rugs. Uh-huh.
area rug like that that's heavy. You don't ever pick that thing up.
No.
I mean, I don't. I vacuum it and clean around the table and stuff like that. But now we're at the point I'm moving out of the house, and we move that dining room table, and we start rolling up that rug. And guess what I found? You know it, Julie. Say it. What was under that rug?
Is it mold and mildew?
Oh, worse than that.
Is it a
Termites.
Oh,
Termites. And that was
that's not good.
oak floor. And so at this point, the deal was done. We're getting the stuff moved out. And I quickly had my contractor go over there and pull all that wood up and replace all the bad ones. And believe it or not, he matched that stain.
Nice.
It looked brand spanking new. But what should I have done? What I did?
Some sellers would agree with you, and some sellers would have done the exact opposite. And that's because, remember, there's verbiage in here. This is at the time of offer. So if the termites were there at the time of offer, prove to me they weren't. You know what I'm saying? Like, prove to me that you added them after the fact. You know what I'm saying? And that's the kind of thing, Jeffrey, that can launch buyers and sellers in court, or have them terminate on the 11th hour.
Before
These
I
are
was
the same
licensed,
figureheads that made me remove the hot tub, okay, at the last minute. So, they wasn't in my favor anyway. I was already pissed at them.
So this
before
is,
I was
this is
licensed, my husband and I have always had the debate of whether or not we need to repair the holes in the walls from like picture frames before we move. And I'm like, no, they saw the picture was on the wall. Like, they knew there was a hole there. If they don't want to use it, then they repair the hole and paint over it. I'll leave the paint.
And all of this is covered. All of this is covered because of how often this comes up. How many sellers say, do we need to fix this? How many sellers say, Do we need to repair the holes when I take these pictures down? Nail hole or fist hole, do we need to repair it? So referring back to the contract, knowing the contract. And again, also remember, you guys, I can't make anybody do anything. All I can do is say, this is what the contract say. And like the water heater guy, I'm pretty sure my agent didn't want to terminate on Friday. You know what? I talked to him today. He didn't want to terminate today either. But it was the buyer's decision. It was the buyer's choice. And that's my job. I provide the facts for them to make the informed decision. Do we win all the time? No. And that's what I always call the dark side of real estate. It doesn't always close. It doesn't always go according to plan. But
Well,
I
you
do
know,
believe this.
holes, they're going to paint the room again anyway to
Maybe,
their maybe.
maybe they'll move in and paint. Maybe they won't.
You bet that seller had somebody out today to get that water heater repaired though, or
Before they go back on the market. Y'all know I'm going to watch that listing, don't you? You know, I'm gonna watch it.
brand new water heater.
That used to be a
Exactly,
cheap
that's what I'm
fix,
gonna
but it's
see.
not anymore.
Huh?
That used to be a cheap fix, but it's not anymore. A water heater. You used
You
to buy a
know?
water heater for what, $350,
And
$400?
again, it wasn't the water heater that broke the deal. The water heater was the straw. It was one thing after another, after another, after another. And the water heater came up and they said, you know what? We're done. During the buyer's due diligence, still in the buyer's due diligence, their obligation to repair. So anybody that the buyer hires for inspections and investigations, the buyer's on the hook for any damage they cause to the property. It's another good reason, guys. Make sure you're using certified, accredited home inspectors. Please don't just go to Google looking for a home inspector. Certainly don't send your buyer to Google looking for a home inspector. We can say, here's a list of 2 or 3 home inspectors I've used in the past that I've had a relationship with. If you don't know anybody, you'll get to know them. But in the meantime, maybe your firm has a preferred vendor list that you can use to make suggestions on home inspectors. And with that being said, even your home inspectors are human, and sometimes accidents and mistakes happen. So just keeping in mind that the buyer's on the hook for any damage to the property. And again, it's very clear here, promptly repair any damage caused by the accepted practices. So any damage caused by the home inspector. What if it was already broken when they got there? That's not going to be on the buyers. And couldn't that turn into a he said, she said? Buyers and sellers happen to duke this out. Because prove to me it wasn't broken. Prove to me that it was.
So we got a home inspection and we bought in the summer. So the pilot light was turned off of our gas fireplace, and our inspector said they can't turn the pilot light on. They're not legally allowed to do that. Is that something that I could, if I was the buyer's agent, could say to the seller, hey, can you turn this on before an inspection to make sure our inspector wants to make sure that it works?
If it's going to cause damage to the equipment, then no, we can't. We can ask, we can request, but if it's going to cause, and to your point, even if there's not a pilot light, if you're getting a home inspection in the middle of August, they may not be able to switch it over to heat to have that checked. If you're doing it in February, they may not be able to switch it over to AC to have that checked because it could damage the unit, right? So those extreme temperatures, and that just may be something that, we have them inspect what they can, offer their opinion. If it doesn't come on in the spring, then unfortunately, that's going to be on the buyer. So there are things that they just can't, like, and that's a great example right there, that pilot light. Absolutely.
It was on our gas fireplace, which we didn't turn it on until like this past year. So 3 years later, almost.
Did it work when you did it fire right
It did, although I did figure out that the logs were not placed properly. And so I figured I had to clean out all of the logs and then clean the whole thing out and realize that it was all good to go, but it took a little while.
Yeah, and that's kind of because we tell the buyer to inspect everything, but there may be things that are limited, things not acceptable. I believe I mentioned this last week, but just in case, because it's worth mentioning again, because it comes up a lot. Listing agents, please always remember that the home inspector can't and won't touch personal property. So if there's boxes, they're packing, right? If there's boxes in front of the door to the utility closet, the home inspector is not going to move those boxes to inspect the utility closet. They're just not going to inspect what's in the utility closet. And there's going to be a gap in the report and you're not going to have a happy buyer. So listing agents, that's something we can do, is to make sure our sellers have the home ready for the inspection. Unlock crawl space doors. I don't know how many times I've heard that one. The home inspector said the crawl space door was locked and they couldn't get in. Doesn't the buyer want to know what's going on in their soon to be crawl space? They want somebody in there. So listing agents, it's worth the conversation with the seller to make sure that the home inspector can get to the places that they can inspect. And then the last piece of the buyer's due diligence, again, was their right to terminate. Again, all they have to do is deliver written notice. They don't even have to tell the buyer why. If they do choose to tell the buyer why, that's entirely up to them. This contract shall be terminated and the earnest money deposit shall be refunded to the buyer as long as we terminate within that due diligence time. And then the last thing, which is what my team went through on Friday. Closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. Obviously, they couldn't work it out. Again, I don't know. I went there. I just kind of got the pieces as they were unfolding. But they couldn't work it out. And all my teammate knew to do was look at his buyer and say, we're not signing. Because what does signing constitute? Signing is the step before closing, and closing is acceptance of the property in its then existing condition. So just never look at a buyer and say, oh, just sign and then we'll figure it out. We're going to figure it out before you sign. And then the last thing we discussed on Friday, or I keep saying Friday, that's not right though, is it? The end of the week last week, whenever we saw each other. Number 5 is the buyer representations. These are things that the buyer is representing to the seller. The seller should be able to rely on this information when they are deciding if they want to enter into a contract with the seller. So the big thing the seller cares about is, how are they going to have the money to buy my home? So we got to tell the seller they're a cash buyer, they're getting a loan. What if, for example, you tell the buyer, we say in the contract that we're going to get a conventional loan. We have a pre-approval for a conventional loan, but at some point, the contract to closing process, the loan changes from conventional to FHA. Is that a change in the terms?
Do you need to amend the contract?
We're going to have to amend that, don't we? Because it's a change in the terms. It's not what we promised. And look, it happens. I get it. Sometimes because we got the pre-approval, right, which is the lender quickly crunching the numbers, we'll say, to spit out a letter so we can go show property. But now that we have the property, now that we have the contract, now they're doing the deep dive. And maybe the lender says, gee, I can get you a better rate if you go FHA. I know I told you conventional, but you can do better if you go FHA. Aren't we going back for round 2 of negotiations? Don't we need to make sure that the seller, because that's not what we promised. We promised conventional. Yeah, Jeffrey.
As long as the seller's getting his money, why does it even matter to have to go back and do this? I mean, if he knows, this is the way it's going to go and it's going to be sold and we're going to close, what does it, it wouldn't matter to me if it's conventional or FHA or VA. It wouldn't matter to me as long as I'm getting paid for what I'm selling.
I think some sellers would agree with you. Absolutely. I think other sellers would be concerned because now that we're going to FHA, we're adding the FHA VI financing addendum. And when we see this form with the FHA, it could give the buyers an out and get their earnest money back if the property doesn't appraise. Even if we're after due diligence, the property doesn't appraise, they're getting their earnest money back. If we go VA, same thing. It could give the buyer an out. And also with VA, now the seller's on the hook for some inspections. So the different products, specifically with the addenda, is different things for the seller to consider. And I agree. I think most sellers would be on board, would agree with you. But you may have others that say, no, I didn't want this appraisal thing to matter. Maybe they know it's not going to appraise.
I think she go gets a drink every time she leaves. So the deal
No,
with
I had to close the door because I like to know that my husband's home. So he's home. So I close my door. But, does it matter to some sellers? Does it matter at all? I don't know. But when something changes, and how am I going to know it's changed? Because now the lender needs an FHA VA financing addendum. Now they need another form. And I got
I
the
don't know.
buyer's agent calling me going, y'all need to sign this. And I'm going, whoa, whoa, whoa. We went under contract with the terms of it being conventional. Is it going to make or break this deal? I don't know. But what I do know is it's something different. It's something the parties didn't agree to. Another thing to consider, if we're going to get other funds, there's so many first time home buyer programs out there, some through the county, some through the government, some through various other sources. And some of those first time buyer programs may require, and this is what this note is telling us, that the seller may be responsible for certain fees and expenses. So again, it's just about representing to the seller all of the information about the buyer's either loan, cash, or other funds that they intend to obtain to purchase the property. We have to represent to the seller if we do or do not have another property to sell or lease. Again, this blue note is telling us I'm not creating a contingency. That's not what this is doing. This is simply the buyer representing to the seller that they do or do not have to sell or lease another property in order to purchase yours. We talked about the RPODs and the MOG. The buyer has to represent to the seller that they have received a signed copy of the RPODs and the MOG, or they have not received the signed copy, or the RPODs or the MOG would be exempt from these transactions. So certain reasons why they might be exempt were instructed to see the guidelines that go over things like court ordered sales, new construction, foreclosure, things like that, maybe reasons why the RPODs would be exempt. And then it also spells out what happens if the buyer has not received these forms, in which case it enacts this 3-day window, either third calendar day of receipt or third calendar day following the effective date. If we still don't have them, the buyer can terminate. And this even goes on to say, including a refund of any due diligence fee. There's very few times that the contract will get the buyer their due diligence fee back. And failure to receive the RPODs or the MOG is one of those few times. Seller breach is the biggest reason why the buyer would get their due diligence back, but we may also come across this. And then that got us through buyer representation. So yeah, it's a quick little recap of what we went through last week. What questions do we have, comments before we look at the rest of this thing?
There is no form for condition on the sale of a previous home. It says it has to be drafted by a real estate attorney. So do we not have, are we not provided one beyond FHA and VA?
We used to have a contingency addendum, but they retired it. They retired that form when they introduced due diligence in North Carolina is fairly new. I'm going to say within the last 10, 12 years, best guess, 15 maybe. It's fairly new in the big picture of life. So when they introduced the due diligence period, they retired the contingency sale addendum because now they said the buyer has the time to sell their home during due diligence, during their due diligence period, or be reasonably satisfied that it will sell during due diligence. So we have no contingencies, and thank you, Kara, for bringing that up, because guess what, guys? We don't have forms for contingencies. I don't have a contingency if I sell my home or lease my home first. I don't have a loan contingency. If the parties agree to add a contingency, then we're having an attorney draft something up. So then the last one is the buyer obligations, was the buyer's obligations under this paragraph. And again, we're going to hit special assessments. We previously defined what a special assessment was. Special assessments is any charge from the government or the HOA, and it is assessed for the improvement of the property. So if the government's doing it, maybe they're adding sidewalks or street lighting. Maybe they're hooking a whole neighborhood up to sewer and public water. If the HOA is putting a special assessment on, maybe they're putting new roofs on the townhomes, or they're paving the parking lot of the condominium complex. But whatever we're doing, a special assessment is defined as an improvement on the property. Now that we're under buyer's obligations, we're going to break down when the buyer may be responsible for special assessments. And we're going to see that the buyer shall take title to all special assessments that may be approved following settlement. So anything that's on the table proposed right now, it's not been voted aye until after settlement. The buyer's not going to be responsible for those until anything that's approved following settlement. We're going to see in just a second then that the seller will be responsible for anything approved prior to settlement. I think a good rule of thumb here, whomever owns it when it's approved is going to be the one that's responsible for it. Responsibility for certain costs. Buyer shall be responsible for all costs with respect to their loan. The buyer is responsible for all their loan costs. Charges by an owners association or management company vendor as agent of the association. Buyer's responsible to pay for the appraisal, the title search that their closing attorney handles, title insurance, any fees charged by the closing attorney for the preparation of the closing disclosure, seller disclosure, and any other settlement statement, recording of the deed, preparation and recording of all instruments required to secure the balance of the purchase price unpaid at settlement. And then the last piece is their authorization to disclose. Buyer authorizes the lender, the agents, closing attorney to provide this contract to any appraiser employed by the buyer or the buyer's lender, and to release and disclose any buyer's closing disclosure, settlement statement, or disbursement summary, or any information therein to the parties, their agents, and the buyer's lender. We do this without even thinking about it. We go under contract. We have a signed contract in our hand. The first thing as buyer's agent we do is we send that contract to the lender. We send that contract to the closing attorney. The lender signs the contract to the appraiser. Everybody that needs access to this contract gets it. And they do because the buyer gives them permission to do so in the contract. The seller will as well. So both parties give permission, whomever needs this contract to do what they need to do as part of their job through contract to closing, they have the authority. We have the authority to send that. So 4, 5, and 6 are all about the buyers. 7 and 8 are all about the sellers. Yeah, I used to have an agent. I loved her. She color-coded a sample offer to purchase and contract. And anywhere that talked about buyers, she highlighted it blue. And anywhere that talked about sellers, she highlighted it yellow. Anything that talked about money, she highlighted it green. And she had one master copy. And whenever she started talking to a new buyer, new seller, and she was giving them the sample offer to purchase and contract, she gave them her highlighted. And if she was talking to buyers, she would say, I need you to pay attention to what's blue and green. She was talking to sellers, I need you to pay attention to what's yellow and green. She really tried to help them sort this out so they could look it over for their best interest. At the very least, make sure you're giving a sample copy to buyers and sellers early in the relationship so they have it to look at. So 7 is our seller representations. Again, this is information that the buyer should be able to rely on when deciding if they want to enter into a contract with this seller. So the first thing the seller wants to do or needs to do is represent how long they've owned the property. Either they've owned it for at least a year they've owned it for less than a year, or they do not yet own the property. I'll get to do not yet own the property in a second, but who is the seller that might own it for less than a year?
He might be
Someone,
flipping houses.
or someone who
Yeah.
inherited it.
Yeah, the inherited. I would say, the buyer's remorse. You have lots of reasons why people that own it for less than a year, but I agree. I think the number one reason why we'd own it for less than a year is a flipper, an investor who their whole job is to come in, flip it, and turn around, put on the market, and sell it. Some lenders, some loan products care about how long the sellers own the property. For example, what's the difference in the loan products? FHA requires a seller to own the property for 90 days before they sell it. So if you're the listing agent, or even if you're the buyer, if they've only owned it for 85 days, then we won't be able to enter into a contract. We need to wait. So different lenders, different loan products may just have different terms. Who's the seller that, an example, who may be the seller that does not yet own the property? I think Gabe's saying foreclosure. He's shouting at us foreclosure. That very well could be. The bank may not use this contract form. If the bank owns the property, the bank's taking the property, they may not use this contract form. They may have their own form that they use. Have y'all heard of wholesalers? They're here. Wholesalers aren't regulated yet. The commission's working on them. And the problem is there's not one true definition of a wholesaler. But I think to keep it simple, if we can overall think of wholesalers like Costco, so they buy in bulk and then turn around and sell in bulk. And it might be that they're in the process of turning around to sell it when they haven't even bought it yet. So wholesalers very well may be that candidate that doesn't yet own the property, but they're in process. We had a situation not too terribly long ago where the buyer hired the builder to build property. They found a lot, they found what they wanted. It was a tear down house and build on the lot that, after we tore the house down. The deal was that the builder was going to offer a package deal. So the builder was going to buy the property, tear down a house, build it, and then the buyer was going to buy it from them. In that case, the builder hadn't yet owned the property. So if and when you come across this, well, the first thing I want you to do the first time you come across this is just go straight to your BIC and say, I got a wholesaler, I got a builder that doesn't yet own the property. But we just want to make sure, and your BIC will guide you through it. But the big question of that is, what happens if it doesn't close? So just being careful, go into your BIC. Most of the time the builders work out. I'm not saying wholesalers are bad. I would never say they're good or bad. But what I am saying is there's not much regulation yet through the commission. Yeah.
So when we're filling this out, if we're a buyer's agent, are we leaving the seller representations blank and having the seller fill that in when they sign the contract, or are we talking to the listing agent to figure that information out?
I can find most of this in MLS.
Okay.
So when I look in MLS, it tells me the seller's ownership. That's one of those required fields that the listing agent will have to do. And to your point, Kara, if you don't know, if you're filling this out and you don't know, then we're going to call the listing agent, because when I present the offer, I need to present a completed offer. So MLS is always going to be our first place to start. Lead-based paint, anything built, don't look, anything built prior to what year?
78.
1978. Are you dreaming about that year yet? Guess what? Once you get out of post and pre, you don't have to remember that year anymore, but we got it so ingrained in you. I know we do. The contract tells us lead-based paint, property is residential, is built prior to 1978. If so, we're told to attach the lead-based paint or lead-based paint hazards disclosure addendum. Big red warning: if a lead-based paint disclosure is required but not given to the buyer prior to seller's acceptance of this offer, buyer may not be obligated to purchase the property under the contract under federal law. Remember, when we're dealing with lead-based paint, that's a federal law, and federal law is going to override state. So this is the one place that caveat emptor, Doesn't matter. When we say the seller doesn't have to disclose much, this is what the big exception is. If they know of lead in the home, then they have a duty to disclose that. Lead-based paint addendum is another one that we will look at in our Fun with Forms. Seller's got to represent if there's an owner's association and if any dues. Seller authorizes and directs any owner's association, management company, insurance company, attorney to release to the buyer true copy of the following. And you can see here a list of documents that may be included in the owner's association with the HOA. So there's our covenants, bylaws. Some have them all, some have one or two. All HOAs are a little bit different. This exact same list shows up in the listing agreement. So we can have these conversations with our sellers up front when we're listing the property. A good buyer's agent is going to ask for HOA documents. A good buyer's agent is going to want a copy of the covenants. So if we can go ahead and get them from the seller now when we list a property, then we'll have them available to provide what we can to the buyer's agent. And then we're going to look at who the HOA is. So the name of the association, regular dues are X amount per month, per quarter, per year, however those are spelled out. And the name, address, phone number of the president of the owners association, or any contact information, website. And then you see we got a place for two. Some places have two HOAs. Some might be, you might have the mandatory HOA, and then you have the optional HOA for the pool, for example. All the seller is doing is disclosing, representing the various HOAs. It might be like a gated community with different sections. You might have one HOA for the whole gated community, and then each section has their own separate HOA. So just depending on how they were set up, how they were established. And then we get into fuel. I think we mentioned fuel last week. Jeffrey had something with fuel. Fuel is one of those things in the contract that's been revisited, and it is revisited often. Once upon a time ago, fuel was scattered all throughout the contract. You had to hunt and peck it to find it. I'm going to say just a couple, 2-3 years ago, the Forms Committee put everything about fuel in one nice, neat little package for us. So that was very appreciative. We can find what we need to know about fuel. Under the seller representations, so to the best of the seller's knowledge, there is or is not a fuel tank located on the property. If yes, complete the following. So first off, I want a description. Tank 1 and tank 2, is it currently used or not? Is it owned or leased? If it is leased, we want the name and contact information of the lessor. Where is it? Above ground, below ground? What's in it? Oil, propane, gasoline, or other? And then name and contact of the vendor. We go through that little exercise again for tank 2. Tanks included in the sale. Buyer and seller agree that any tank described above that is owned by the seller shall be included in the sale as part of the purchase price, free of liens, unless excluded in paragraph 2E above. 2E above is where we excluded our fixtures. So if the tank's gonna go, if the fuel tank's gonna go with the seller, then we're instructed to exclude it where we exclude other fixtures, 2E above. Fuel. Seller may use fuel in the tank described above through settlement, but may not otherwise remove the fuel or resell it. Any fuel remaining in the tank as of settlement shall be included in the sale as part of the purchase price, free of liens. Seller's use of fuel in any fuel tank is subject to their obligation under 8C, we're getting there, to provide working existing utilities through the earlier of closing or possession by buyer. So the seller's got to keep existing utilities. We're going to see in 8C. I mean, if the buyer is supposed to do inspections, they can't inspect it if we don't have power or, you know, the hot water on or electrical or something. So the seller's got to keep those utilities going. And that would also include fuel. So it can be inspected if necessary. And then a couple blue notes. Buyers shall be entitled to conduct inspections to confirm the existence, type, and ownership of any fuel tank located on the property. Buyers advised to consult with the owner of any leased fuel tank regarding the terms under which buyer may lease the tank and obtain fuel. And then state law provides it is unlawful for any person other than the supplier or the owner of the fuel to disconnect, interrupt, or fill the supply tank without the consent of the supplier. This is because we had sellers out there trying to pump fuel out of the fuel tank the day before settlement. And they were putting in like their lawnmower gas tanks, you know, they were just trying to get their fuel. Fuel is probably one of the things, I don't know how many times buyers and sellers have wound up in court over fuel. So the contract is pretty clear right now about who gets the fuel. The seller can use the fuel, and whatever's left, then the buyer gets its settlement. And hopefully this resolves some of those disputes.
When I sold my house, they came back twice and had to measure my fuel. Worried about that. But the other thing, and I forgot about this till we started talking about tanks and stuff. I owned that tank that was in the ground. It was mine. I paid for it. The house I'm living in now, unfortunately, is owned by Ferrellgas, which I've tried to buy from them, which they fight me tooth and nail. They don't want to sell that tank. There's a good reason behind that. And then I told you I had gas and electric hot water heater in my house, and I'd switch back and forth. They made me remove the gas hot water heater. So once it was removed, it was running totally off electric. And the only thing that fuel tank fueled was my fireplace and my grill. I've had a separate line running out there where I never had to worry about switching a tank, you know.
Nice.
But yeah, that is nice. You don't have to worry. But the reason they don't want you to own your tank out here is because I can get my fuel from anybody I want. But if they own the tank, even if they're 10 cents a gallon higher on a 1,000-gallon tank, you can see my reason in wanting to buy from somebody else.
Yeah.
They want to put their fuel in there and get their price out of it.
Yeah.
And it's illegal for another company to come in and fill that tank.
I was going to say there's probably a big sticker on it. So something along the lines of we're the only ones that can touch it, you know, something along those lines.
Can't see them. It's buried except for that submarine head on the top of it. But yeah.
Yeah. Again, this should come up. Listing agents, we should have these discussions at the listing. So we're going to ask the seller a series of questions in the listing agreement. And some of those questions are going to be about fuel. Now, this is what's going to happen because it's fuel. It's the fuel that gets people. The seller's going to look at you and say, I just paid to have this filled last month. And you're telling me that I can't take my fuel with me. I just paid, you know, $800 to have it filled. And you're telling me that the buyer gets whatever I don't use. So, you know, what can we do? Well, I can list your home for $800 more than I think, you know, get that wiggle room in, try to get that in the purchase price. But you know, it kind of goes back to what we were saying. What does the contract say? Now, hopefully, you know, the seller's not going to have a, you know, fuel party and try to use as much as they can. But I mean, they have that right to do so because especially if they're still living there, you know, they have the right to use that fuel that's in the tank, but they've got to leave what they don't use. So that's where we can work it out in negotiations, maybe in the purchase price, you know, whatever. But I am so glad that they have, I don't want to say fix it because that would imply there was something wrong before, but they have revamped this. I think it's pretty clear about what each party's obligation is, what party needs and needs to not do with fuel. And hopefully we're not going to court as much. I don't believe we won't go at all, but hopefully we're not going as much now that we've better defined what that fuel is. How long ago was it that you sold, Jeffrey, roughly?
Oh gosh, 20 years ago.
So the contract did not look like this 20 years ago. And it's
there
all
none of this
cases that have led us to to this. It's those exact same types of incidences that have led us to this.
There was nobody. I mean, I was selling my house, and the agent was working, of course, for the buyer. They wasn't working for me really.
Right.
They were. I mean, everything was falling on me. I had nobody on my side really. I mean, because you didn't have everything you got today.
Yeah,
So it's
that's
changed a
true.
lot.
It's a totally different ball game, isn't it?
Yeah.
All right. Break time. Let's take 10. Let's see. I got 6:10-ish now, so let's come back at 6:20 and we keep going. Like we're having audio, not we, you are having, because I couldn't hear you earlier when you were sharing, when I was sharing.
Should be working.
And now it's working.
Yeah. Whenever you're presenting, but I think I have to rub the mic like Jeff was saying. That's the only way it'll work.
So weird. I don't understand like I pretend. I don't pretend like I understand technology. Let me put it that way. I don't even for a second. I'm going to stand here and pretend that I know what's going on because I don't.
Neither do I. I mean, I tried everything. I mean, I uninstalled it, reset my PC, went directly to the site. I tried a lot of things and nothing worked. And then Jeff is like, rub the mic and see if that works. And then boom, it works. And it's just like Jeff is the tech whiz here. So
He's our tech whiz.
yeah.
Awesome. Good to know.
Bless you, my son. Bless you.
Yeah. Thank you. Thank you.
There's a genie in there.
That's right.
So what? What'd you say?
A genie.
A genie. He has a genie in his camera or
Genie.
microphone that he needs to just activate every time he.
Right. Yeah.
Make it
Did
one
you
of your
see the
wishes.
purple in those flowers that you just had on the screen?
Say it again.
Did you see the purple on that previous that right there? The purple, the lavender. Believe it or not, I was working in the garden. Did I tell you this? And I dropped one of those things that you drive a stake in. You got two handles and a metal thing in the middle. And I was driving it in the ground, and I used a different stake, and I brought it up too high, and I dropped that 18 and a half pounds on top of my head. I came down like that and
Oh
hit
my.
myself in the head. Everything turned that color. The grass, the trees, the garden, everything was purple. I thought I was right there at blacking out.
Oh my.
I'd never done that before in my life. I like
Wow.
telling, if I do something stupid, I'll share it so nobody else does it.
I was gonna say you're gonna go all the way, aren't you?
I did. I've got a heck of a knot up here.
Oh man. Well, we are so glad you're okay now.
Oh yeah, I'm as crazy as ever.
Accidents. They're not called predictions or plan aheads, are they? They're
I didn't see that one coming.
all right, let's see. Where are we? Seller representations represented about fuel. The only other thing the seller has to represent to the buyer is if the property is or is not subject to a lease, any existing leases. If the property is subject to a lease, buyer and seller should include this provision in the additional provisions addendum, again, another form that we will look at, or the vacation rental addendum with this offer. We'll briefly discuss the vacation rental addendum. The additional provisions addendum has a whole section for the seller. We'll see to disclose rental income. Is there any, issues with the tenant? Basically turn the books over. The additional provisions addendum allows the party, they got to decide what to do with the security deposit. So we'll see that. Or if the property is currently being used as a vacation home, then you have the vacation rental addendum. Archdale, Winston-Salem, Wilkesboro, Salisbury, they're all lovely. But the truth is people are not vacationing here. If we were to move down to the coast or up to the mountains, we would deal more with vacation properties. So just kind of keep that in mind I'm not saying you don't have vacation homes, but not as much. We're not dealing with it as much here as what we are in other parts of the state. And then we got the seller's obligations. What are their obligations to the buyer? Seller agrees to use best efforts to provide to the closing attorney as soon as reasonably possible after the effective date, copies of all title information in possession of or available to the seller, but including not limited to title insurance policies, attorney's opinion on title, surveys, covenants, deeds, notes, and deeds of trust, leases, easements relating to the property. So really what the seller is doing is they're agreeing to work with the attorney. If the attorney finds any issues with the title, they will have to get with the seller to clear that up before settlement. The seller's big responsibility here is to provide, we'll see, provide clear marketable title. So if there's anything standing in the way of the seller doing that, then that's what the attorney's job is for. That's what the attorney's doing. Please always remember, the buyer hires the closing attorney, which means the closing attorney has the buyer's best interest. And it is their buyer client's best interest to make sure they are getting clear marketable title. So whatever documents the attorney requests, whatever information they may need from the seller is agreeing to work with them to prove that evidence of title. Seller shall provide to the closing attorney all information needed to obtain a written payoff statement from their lender regarding any security interest in the property as soon as reasonably possible after the effective date. Seller designates the closing attorney as seller's agent with express authority to request and obtain seller's behalf payoff statements and on short pay situations from any such lender. At some point in the contract to closing the process, the lender needs to know what the seller owes. And so they will, for the most part, they will reach out to the seller's lender and request a payoff statement, and they got to request it for or to that date. The seller will have to pay interest that day. The seller will have to pay any closing cost or loan costs that day. Anything they owe their lender, they will owe for that day of closing. So my homeowners on the call may tell you that when they log into their mortgage account or when they get their mortgage statement in the mail, it may give them a number, but then it clearly says this is not a payoff balance, because that payoff balance doesn't, again, it doesn't take into interest through today, various other charges until the day of settlement. If settlement gets delayed, we may need another loan payoff. That number needs to come back and recalculate, because remember, let's go back to my guys. They were supposed to close on Friday, and at one point they thought it was going to happen today. They decided today it wasn't going to happen. But if we're supposed to close on Friday, seller owes their lender interest until Friday. But then we decided one point we thought we were going to close on Tuesday. So there's Saturday, Sunday, Monday, and Tuesday. There's 4 more days of interest. Doesn't the lender want all of their money? So they would go back and recalculate to include those 4 days of interest had they decided to close. In all my years, I've only had one attorney that would not reach out to the seller's lender for their payoff balance. And that's great. I just needed to know to do it. He kind of got a little funny with me. He called me a few days. He was like, what's your sellers owe? And I'm like, they have an approximate balance. He was like, well, when are you going to instruct them to call their lender? I was like, as soon as we hang up, sir, thank you very much. Now that I know, I'm happy to get on it, but sometimes just knowing is half the battle. So they called, they got the payoff. That's the only attorney I've ever had. Everybody else says, we'll do it. We'll take care of it.
You would think that the attorney would need to be the one doing that, because who's to say that the other guy's not going to lie about it?
That's what I thought. If my sellers really didn't act like they knew what that meant or what they were doing, and I thought, gee, for the attorney's peace of mind, you thought that they would want to. But by the way, I only used that attorney once too. Not necessarily because of that, but it's something that you tend to remember going forward. You know what I'm saying?
Well, if it was the wrong amount, that would fall back on that attorney.
That would fall on that attorney. And ideally closing shouldn't happen. Because if they don't have the money to pay it off, then they're not going to be able to record the deed of trust release. So when the attorney's recording stuff, they have to do things in that date and time stamp matters. So they want to show that the seller paid everything off before they record the buyer's new deed. So if they can't show that, then they can't record the buyer's new deed. And now we got a delay. That's probably why I only had the one. Everybody else, I agree with you, Jeffrey. All the other attorneys are like, let me do it because I know what I'm asking for. I know what I'm looking for. As soon as reasonably possible after the effective date, seller shall provide to the closing attorney all information needed to obtain a written statement of the seller's account from any owner association or HOA management company. Seller designates the closing attorney as the seller's agent with express authority to request this information. Upon request from the closing attorney, seller shall immediately pay any fees charged by the HOA for such written statement. So again, we got the attorney. In my experience, we got the attorney reaching out to the HOA to get specifics about what those transfer fees are, who's responsible, making sure they know the date that this is going to take place. The HOA management company also needs the buyer's information because when the buyer buys, they now are in that HOA. So the HOA will have to enter them in the system, process them, that kind of thing. So in my experience, we got the attorney also reaching out to the HOA, if applicable, to get the information they need from them. And then, let's see, we're still under seller's obligations. If the seller is not a foreign person as defined by the Foreign Investment and Real Property Tax Act, seller shall also provide to the closing attorney a non-foreign status certificate. In the event seller does not provide this certificate, they acknowledge that there may be withholdings as provided by the IRS. So different foreign, non-foreign statuses of sellers, it may affect their taxes, that IRS thing. Again, this shows up in the listing agreement. So we can have the conversation with the seller. If they fall under this Foreign Investment and Real Property Tax Act, then we're just advising them to communicate that with the attorney so they get that certificate. It's not going to make or break the sale, but it is going to affect their, their taxes, how those may or may not be due. Yeah.
This may fall under commercial, and you may have to correct me if I'm wrong, but I think the state of North Carolina is now working on where a foreign entity cannot own farmland or businesses in North Carolina. So I know the Chinese bought a bunch of farms in the eastern part of Wilkes County, poultry farms. And I actually, at this point, I was willing to entertain the thought, of them buying mine because I had one as well. And, but I was too far west of their east, for them to do it. But the point being is, and the important thing there is, if the Chinese kept buying up those farms, who would run the Tyson plant in Wilkes County? If you got all the birds and all the farms, instead of them telling you what to do, you're now telling them what to do and when you're going to do it. So it was interesting the way that came about finally. Took 4 years.
Thank you for sharing that, because that's interesting to hear that that's in the workings in at least commercial and agriculture. I'll be interested to see how that plays out in residential, especially in the investment world, the investment piece of it. And when in doubt, if your seller looks at you and says, well, I don't know, or I'm not sure. I mean, seriously, I could copy Foreign Investment Real Property Tax Act. This is why they give us like names of the act and they reference general statutes when necessary. Throw that in Google. Let's see, with the seller, let's see if this is something that we even need to worry about, or anything we need to deal with. Tara, I'm so jealous. You're totally eating my favorite candy of all times. See, you're nerds. Nerds are the best. And any variation of nerd.
It's a nerd cluster. I don't know. There's like gummies inside of it, and then it's surrounded in nerds.
They're addictive.
I'm a fan. The best candy ever.
I had to hide them from my kids, so
you have a candy stash. I think we all should. All right, seller obligation authorization to disclose information. This is pretty much exactly what we just saw in the buyer's piece, only now we got the seller agreeing that anything that the attorney needs, the lenders, the title insurance company, anybody involved, they're going to get a copy of this contract. They need to do their job. So again, this is just their, it saves us a step after we go on a contract to say, can I send your contract to the lender? Can I send your contract to the closing attorney? We already have that permission to do so. We have that authorization. Access to property. Seller shall provide reasonable access to the property through the earlier of closing or possession by buyer, including but not limited to allowing the buyer, their agents, or representatives an opportunity to, number one, conduct due diligence, investigations, or inspections. The seller can't go under contract with the buyer and then not let anybody on the property to do investigations or inspections. That would kind of negate the whole due diligence period, right? So the seller, and again, that's reasonable access. So like we were talking about earlier, your buyer may want to go to the property a couple times, but let's see if we can't coordinate it when the home inspector is going to be there. Bring your tape measure or your paint samples or your priest when the home inspector is going to be there. Maybe we try to coordinate all the inspections at the same time, especially, you guys, especially if the seller's still living there. Let's try to be very considerate about the fact that they're living there, and not, try to bombard them. But we do need to have the buyer on the property and their representatives to do their due diligence. Access to property, buyer needs to be able to, number two here, verify the satisfactory completion of negotiated repairs or improvements. It's one thing for the seller to say, yeah, I'll fix it, and yeah, it's fixed. It's another thing for the buyer to be able to go back and verify the satisfactory completion. Maybe they want to put their eyes on it. Maybe they want their electrician to go back out if it was electrical thing that we negotiated. I know some home inspectors will go back out for a lesser fee and re-inspect the things that we had fixed. So if I told my home inspector they fixed this, this, and this, then they would go back out for a lesser fee and inspect those items that we were agreed to. It doesn't specify how the buyer verifies those completed repairs, but just that they have the right to verify as such. And then number three here, access to property. Seller's got to let the buyer conduct the final walkthrough. If I ever came across a seller that said, do they have to do the final walkthrough? I would be very, 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 very concerned, especially in a property that we've never seen vacant before. If your seller just moved out yesterday and closing's tomorrow, guys, we need to do the final walkthrough. If you've only ever seen it vacant, we need to do the final walkthrough. We need to encourage our buyers, and if they can't or won't meet you at the final walkthrough, I need you to do it as a buyer's agent, and I need you to document it. I need you to go through the home videoing, because what's stopping that buyer from moving in and saying, oh, there's a big hole in the wall, and the seller saying that hole wasn't there when I moved out. So if we go through either with your buyer or on your own videoing and documenting, just so we all are on the same page about the condition of the property, as close to settlement as we can. I almost always do my final walkthrough like on my way to the closing attorney's office. We're going to see things as close to settlement because of that one very important sentence. Closing shall constitute acceptance of the property in its then existing condition. So if you don't know its then existing condition, what do you have in your buyer sign? So we got to do that final walkthrough. I think most of my buyers have come with me. I've only come across one that's like, no, I'm good. And I'm like, well, I'm not, so I went and did it anyway. I documented it all with my phone. I had friends of mine, good girlfriend of mine and her husband bought several years ago. And we only saw the home occupied. The whole time we saw it is occupied. And I don't know when the sellers moved out, but the morning of settlement, we were doing the final walkthrough, and it was the first time that we're seeing it vacant. And so, I told my girlfriend, I was like, this is the first time we're seeing this home vacant. We need to look in, all the pantry, the closets, we need to do like a very thorough final walkthrough. You should anyway. So, but we need to make sure because we've never seen it vacant. And this home had it had the pull down stairs in the attic, the string in the middle of the hall, and you pull the stairs and they unfold. And so she said, can I poke my head up there and make sure they got the stuff? And I said, yes, this is part of the final walkthrough. So she climbed up there, and lo and behold, all the stuff that was there when we saw the home pre-offer, all of it was still there. Nothing was touched, nothing. So I called the listing agent, standing in the living room. I called the listing agent and I said something about the stuff in the attic. And she was very quick to respond, well, that's not their stuff. Okay, it's somebody's stuff and it's in the home. And I know what the contract says, so we got to get it out. Finally got to the bottom of this, y'all. It was the previous owner's stuff. The
Wow.
current owners in 6 or 7 years had never once poked their head in the attic. Never once. It was the previous owner's stuff. Let that sink in just for a second.
A
This
body.
is better. You ready?
There's a body.
Do what, Jeffrey?
There's a body up there.
So the agent that was the listing agent, she also helped them buy 6 or 7 years ago. They called her mom. So evidently when they bought, mom, i.e. their agent, never suggested that they looked in the attic. Nobody ever told these young homeowners that the whole time they need to look in the attic. And now here they are go, that's not their stuff. What's the contract say?
They have to get it out.
Got to get it out. We'll see that. And if not, closing accepting its then existing conditions. So I told my girlfriend, you want it? There might be treasures up there. Jeffrey went straight to the body. I went to treasures. There might be something worth value up there. What do you want to do?
There's a box of money.
Talk about grandma's antique chandelier, right? It could be stuffed up there. And she said, I got my own stuff. I don't want somebody else's stuff. I want it out. So I called the listing agent and said, this is what's up. Y'all, I tell you, her and I, we finished our final walkthrough. We went on to breakfast because, that's what we did. They met us at the closing office, the closing attorney's office later. You could see they were glistening. They were, because they had to get the stuff from the attic and get it out on the curb. They had to get it out of the property because my buyer didn't want it, because we did that final walkthrough. Don't assume they get it out. Never assume. Any final walkthrough, again, look in the kitchen cabinets, look in the closets. Sometimes things get left behind by accident. But wouldn't we rather know about it now, get this addressed now? You can call the listing agent and say, they didn't grab their winter coats in the front closet. You know what I'm saying? We can have these conversations now, so it's not an issue. It's not a problem later.
Okay. Were you saying that the people that lived in there last was the child of the agent that sold it to them? So it was the agent's stuff that was upstairs in the attic.
No. She was the mom of the sellers. The agent was the mom, and she was the listing agent now. But when they bought it, she was their buyer's agent.
Okay.
And she never told them to do a walkthrough or look in the attic.
Evidently not, which is why she was super quick to say, that's not their stuff.
Well, she knew it wasn't their stuff.
Really? Really? Guys, the final walkthrough, again, even if your buyer doesn't get the value of it, even if your buyer says, oh, I'm fine, I don't need to, please do that service for them, because remember what they're signing. Remember what they're agreeing to. Imagine a world where they refuse to go and then they come home after getting their keys and saying, what are all these holes in the wall? What is all this stuff in the attic? So make sure we're doing that final walkthrough. Last piece, access to property. The last sentence, again, very important. Seller's obligation includes providing existing utilities operating at seller's cost, including any connections and de-winterizing. So if it's February and the pool has been winterized, maybe it's a vacant home and they've had the water turned off, who's responsible for making sure that the buyer has that water so they can do their inspections?
Seller.
Seller. Seller's got to keep existing utilities operating at their cost. Sometimes sellers say, especially vacant homes, woo, I'm under contract. I can call, the city and cancel my power. No, they've got to keep that on through closing. Blue note says, see warning in paragraph 4 above. That was the buyer's due diligence for limitation on buyer's right to terminate this contract as a result of continued investigation of the property following the expiration of the due diligence period. I am going to go back up just for 1 minute to see that, because I think it's important that we see it. I know we saw it, but we need to make sure that we see it. And what that was referring to, back up under buyer's due diligence, starts with a big red warning about why the buyer should conduct their due diligence. And understand, when due diligence is over, the buyer can still continue to investigate the property. Due diligence doesn't end the investigations and inspections. The only thing that the due diligence ends, it ends the buyer's right to terminate. The buyer can still do inspections or investigations up until closing, and they often do in that final walkthrough, the very last act of their inspections or investigations. So at the end of due diligence, they haven't lost their right to learn about the property. They've lost their right to terminate. Their easy out is over. And that's what they're giving up at the end of due diligence. They're giving up that easy out.
So if the seller does not keep the utilities on through closing, what is the remedy? Because I've heard that's a very common mistake.
It is, and we don't really have a remedy. Hopefully it's something the parties can work out. If the buyer can't investigate because there's no water or electricity, then they may choose to terminate. Could they go after the seller for their due diligence fee? Possibly. I don't know if they'll win or not, but their options are to terminate or not. And if they choose to bypass the inspection because there's no water, then they sign agreeing to accept this property in its then existing condition. So Kara, that's a great point, because it does come up, and it's something that the parties are going to have to agree to. It's something that the parties are going to have to work out. Yeah.
What I did when I sold my home was I called Duke Energy and told them on July 1st to terminate my power, and it would switch over to the buyers. But my power was to be turned off on July 1st. I'm just making that date up. July 1st, yep. And it will be taken over by them. So that's how I did all my utilities and stuff like that. As far as like cable and stuff, it was turned off. I just turned it off.
Yeah, but when it's closing has to be July 1st. That's what you have. So when you are calling your utility company, and this is what you tell the buyer or your sellers, is that when you are calling your utility company, you call them and tell them the closing date. And if the closing date gets pushed for any reason, you have to call and change that date again.
Get it extended. And buyers agents, we need to tell our buyers, you need to call the utility company and arrange to have these services turned on this date. Right. So both parties should be talking to the utility companies, the ones that are going to stay. Because the utility company is probably going to they need an application for the buyer. They might need a deposit, right? They're going to need information. And really what they'll do will just be seamless. You and I will never know when they switch it over, right? So it's not like there's a loss in power. They just do it all on the back end. But they got to know who it's coming from and where it's going. So both sides, both agents, we need to talk to our buyers about utilities.
We bought a house not in North Carolina, but we got a water bill for when we didn't own the property and it was like a backwater bill. And we contacted our real estate agent in that state and just said, hey, can you see if the buyer or if the seller will take care of this? Because this wasn't our water bill. They did end up doing it, but ultimately, like, we would have been we were the ones responsible for it because it was because that was our house now.
Now it's in your name. Yeah. Yep. So it's good that they have, because if this goes down and we need to investigate, it's good that they have when the seller contacted them, and it's good that they have when the buyer contacted them, right? So hopefully they can resolve any of those things. Yeah, same thing with water. I mean, and Jeffrey, to your point, I mean, yeah, I'm turning cable out when I'm moving out. That's not a requirement to live here. I'm not going to transfer internet, cable, that kind of thing. I'll tell you who I used. You're welcome. We got choices now, right? It used to be there was a cable provider, internet provider. Now we have options. So maybe they want to search around and find their own. Buyer's agents, there's just things that we need to help our buyers through that process. Your firms may or may not have checklists. I'm such a fan of checklists. And with our checklist, when we go under contract, here's a set of things that I need to tell my buyer. Closer to due diligence, I need to tell my buyer this. As we're closer to closing, here's the list I need to give them. And that list is turning on those utilities, getting those utilities in your name. Removal of seller's property. Seller shall remove by the date possession is made available to the buyer all personal property which is not part of this purchase and all garbage and debris from the property. So the seller needs to get their stuff out. Anything we didn't agree to, the seller needs to get their stuff out. Again, the benefit of doing the final walkthrough. Some sellers, y'all, this is what happens. Moving day rolls around. They decide they don't want to mess with it. So let's leave it as a gift. Y'all, if the buyer wanted your grill, they would have asked for your grill in the offer. If buyer wanted the thing you didn't want to move, they would have asked for it in the offer. If we didn't agree to it in the personal property or fixtures, then the seller's got to get it out. And it's that simple. And again, we need to talk to our sellers at the time that we're listing it, because we know they got to go somewhere, right? We know they got to pack it up and get it out anyway. I mean, the buyers are not hoping to get a roommate. They're going to get the house. They don't want the people and the stuff in it. Your sellers are not leaving gifts. They're not leaving presents. They're leaving junk. They're leaving their stuff for somebody else. Contract says if we haven't agreed on it, it needs to get out. Again, maybe we can agree to it at the 11th hour, but as it stands right now, only this personal property is not part of the purchase. Affidavit indemnification. Sellers shall furnish at settlement an affidavit or indemnification agreement and form satisfactory to the buyer their title insurance, if any, executed by seller and any person or entity who has performed or furnished labor, services, materials, or rental equipment to the property within 120 days prior to settlement, and who may be entitled to claim a lien against the property as described in this North Carolina general statute, verifying that each such person or entity has been paid in full and agreeing to indemnify buyer's lender, and buyer's title insurance against all loss from any cause or claim arising therefrom. What's this paragraph about?
Indemnification.
And it was about mechanics liens. Anything filed 120 days, that's Gabe up there fixing. He's screaming at us. People in Gabe's house are going, mechanics lien, what are you yelling mechanics lien? No, but that's exactly what we're talking about right here is mechanics lien. So listing agents, when the seller tells you, I'm going to paint the house and I'm going to clean the carpets and I'm going to have the landscaper come and we're going to do this, that, and everything else to get it ready, we just got to make sure it's paid. If the seller agrees to do any repairs, we just got to make sure it's paid. We want to make sure that this doesn't happen. We don't want the mechanic to file a lien on the property, because by the time they file a lien, there's a good chance that the buyer could be the owner. And I know it sounds horrible. We're going to paint and hire, hire cleaners and landscapers. Awesome. How about you show me your paid in full invoices when you're done? I don't have to tell them that I suspect that they won't pay. I'm not saying that. But if I see a paid in full invoice, that one allows me to verify that it's been paid, but we also know who did the work. So making sure that we, what if you're viewing a property to list and they're so proud because they just recently renovated and they just did a major overhaul to the bathroom and the kitchen. They updated the bathrooms in the kitchen. My flag's going up to ask some questions. Did you guys have to get permits? If so, did you get any permits? Do we have COs to close those permits? Was everything paid in full? We got to be wary of mechanics liens. This is why we say we are constantly looking out for those little red flags. Designation of lien agent, payment, and satisfaction of liens, if required by, again, this North Carolina General Statutes. What's required by this North Carolina General Statute? We can copy and paste that thing right into Google and find that North Carolina General Statute. So if required, seller shall have designated a lien agent, and seller shall deliver to buyer as soon as reasonably possible copy of the appointment of the lien agent, all deeds of trust, deferred ad valorem taxes, liens, and other charges against the property not assumed by the buyer must be paid and satisfied by sellers prior to or at settlement, such that cancellation may be promptly obtained following closing. Seller shall remain obligated to obtain any such cancellation following closing. So again, it's one thing to say I've paid it off. We want to see those lien payoffs, deed of release, they're sometimes called. A lien agent would be involved if it's a really big contract, a really big project. They used to say anything over 30,000. They updated that, 2 years ago? And now it's 40,000, 2 or 3 years ago. So you're going to find some outdated literature about that. But just 2-3 years ago, that amount is 40,000. And any project that costs more than $40,000, now we need this lien agent. Good title legal access. This is the paragraph that reminds us of everything that we knew and everything we learned in pre-licensing. Sellers shall execute and deliver, not just any deed, but a general warranty deed for the property in recordable form no later than settlement, which shall convey fee simple, marketable, and assurable title without exceptions for mechanics liens, lis pendens, liens and judgments, free of other encumbrances or defects that would materially affect the value of the property, including these which would be revealed by a current and accurate survey of the property, except for ad valorem taxes for the current year, utility easements on violated covenants, conditions, or restrictions, and other such liens, encumbrances, or defects may be specifically approved by the buyer in writing. The property must have legal access to a public right-of-way. Why do we have to know what a fee simple title is? Why do we have to know what encumbrances are? This is what we feel like in pre, isn't it? Why do we have to know this stuff? Well, part of the answer to that is because it's in the contract. And to me, this paragraph sums up the seller's obligations, the seller's responsibilities and duties. It tells them that they are providing this free, clear, marketable title. And hey, when something comes up on the title search, you do the title search, you're going to find liens. Of course you are. I'll pay them off before settlement. I'll pay them off as part of my proceeds. Easements, the current taxes, etc., etc. There's a blue note. Buyer's failure to conduct a survey or examine title of the property prior to the expiration of due diligence does not relieve the seller of their obligation to deliver good title under this paragraph. If I waive all my inspections, that does not negate the fact that the seller has the duty to provide this clear marketable title. That's their job. The other note is referencing us to a short sale addendum if applicable, and that is another one that we're going to talk about with our Fun with Forms. So we will talk more about the short sale and see that. I often get asked, what if the seller is not using a general warranty deed? Well, then we can't use this contract as it stands. If they're not using a general warranty deed, more than likely it's a foreclosure. And we probably wouldn't be using this contract if it were. Again, the bank's going to have their own for when they purchase and when they sell at the auction or whatever. If you come across a situation where a seller says, well, I'm not doing a general warranty deed, doubt it. But if you do, the seller says, well, I'm only giving a special warranty deed. I need you to get with your BIC. I need you to get with your BIC to find out. And it might be that we got to get your firm very well may have an attorney, or maybe we even call the legal hotline at NCAR. But we need to make sure that everybody's on the same page of what it is the seller is delivering. And 2T says they're delivering a general warranty deed. Government of compliance. This one was just added last year. And again, we're seeing similar verbiage now in our listing agreement with this. So if we have any issues, hopefully we can address them before we get to the offer to purchasing contract. So it is a condition of this contract that the property be conveyed free of any material violation of law, ordinance, permit, or governmental regulations, including but not limited to those relating to building, stormwater, impervious surface, environmental protection, and zoning, unless the seller has specifically disclosed such violations prior to the effective date. So that's important. We'll come back to that. If the buyer establishes that a violation exists after the effective date and prior to closing, the buyer must promptly notify the seller, and the seller may cure the violation. Unless otherwise agreed, if seller does not cure the violation prior to closing, buyer may choose to accept the violation and proceed to closing, or terminate this contract. And check it out. They're getting a refund of their earnest money deposit and also their due diligence fee. So this is what's up. This is why this is in the listing agreement. We're having these conversations with sellers at the time of listing. Are there any issues regarding building, stormwater, impervious surface, environmental protection, zoning, etc.? If so, we want to encourage our seller to disclose. That's all they have to do is disclose, and the buyer no longer has an out. Seller says, no, I don't want to disclose. Okay. Now the buyer finds it in their due diligence, and they give the seller the choice to fix it. And if they say no, and the buyer terminates because they didn't address it, not only are we going to get them their earnest money back, but we're also going to get them their due diligence fee back. And if the seller's not willing to sit down and write out a check, then this will wind up in court for the buyer to collect, for the buyer to get their money back. Again, we can avoid this by encouraging the seller to disclose upfront. Now we're not giving that buyer a choice to terminate after contract. You and I know the seller doesn't have to disclose, right? Caveat emptor. But sometimes it's in their best interest. And that might be, this might be one of the cases that it is in their best interest. Questions on that? Thoughts? Listing agents, I really do think it's having these conversations up front, using that exclusive right to sell listing agreement to prepare the sellers for these things that may or may not come up upon contract formation.
I think I might have a question actually.
Yeah.
It worked. Heck yeah. So it talks about zoning as well. And I guess my question is maybe like how would they cure a zoning problem with the property? I guess they would call the city and see if they could get a variation on that. And then that would
possibly.
have to be completed in the due diligence process?
Or at least part of it. It may not be concluded in the due diligence time, but if the seller agrees to do this, of course, we're going to get it in writing, right? We're not just going to take the seller at their word. But if they agree to do this, then it should survive that due diligence, because the seller's obligations are not part of the due diligence period. Now, this could be a problem, right? If it's something with zoning, and I mean, there's only so much that is in the seller's control. I mean, they can go voice their opinion to the zoning board, but that doesn't mean that they're going to get their way. We'll say that it's going to be heard. Which again, Gabe, may be a really good point on the listing side, why we have the sellers to disclose what they know. That could avoid the whole rest of this. You know what I'm saying? Versus the buyer finding it, and now the seller has his options. Disclose what they know in some cases. Again, this was just added. If it wasn't added July of 2024, then it was July of 2023, but I really don't think it was 23. Maybe it was, but this is something that obviously is coming up right now that we have a whole new bright new shiny paragraph in our contract. This is something that's coming up. So guys, the listing side, again, we keep going back to that, but that can avoid some of these concerns just by having these conversations at the time we list. I tend to use the listing agreement more as a checklist, right? To make sure that we covered everything, to make sure that we talked about everything.
What section is that?
This is 8. 8H, 8 Heather.
It's not in 2022 because we have 2022 in our books.
Okay, so it's either 23 or maybe 24. It's new. It's very, very new in the big scheme of things. This might have been what took our contract from 16 pages to 17. There's something that had to do it, right? And it might have been this paragraph. But again, you're hearing what I'm saying, right? What's this mean to you guys when we get a whole new provision, a whole new section of the contract? It's because somewhere in the world, somewhere in the state, I should say, this is coming up. This is happening. This has been an issue. So they're just trying to prevent these from being issues again in the future. Deed, taxes, and fees. Sellers shall pay for preparation of the deed. Remember we said when we talked in chapter 14 about who pays what? We said the seller pays to have the deed prepared. It's still their deed when it's getting ready. So seller shall pay for preparation of the deed and all other documents necessary to perform the seller's obligations under this contract, and for state and county excise tax, and any deferred, discounted, or rollback taxes, local conveyance fees required by law. This deed is to be made to either the buyer, a corporation, LLC, or other business, a trust for which the buyer is the beneficiary, any relative of the buyer, or other. And we are told to only insert the name if it's other. If we're saying this deed is going to be transferred to the buyer, we need to fill out the buyer correctly on page 1. Make sure you're putting those full legal names of all the buyers, the parties that are going to be part of the deed. Again, the insert the name piece is fairly new. Well, specifically for other is fairly new. They always had us insert the name, but the forms committee said that we're not good about putting names in. So if we can get it right on page 1, then that should be what the attorney relies on, what the attorney should go by. So that takes us back to making sure that we're properly filling in full legal names.
So like, for instance, my husband was the one who was buying the house because he was the one who qualified for the loan. but we wanted the deed in both of our names. So
Yes.
that's where because he was the one listed on the contract. I think I still had to sign his spouse in some spots, but that's where how my name got put on the deed.
That's how your name would get put on the deed. And we would want to make sure, Kara, definitely that the attorney, and this is how we can let the attorney know. To your point, most lenders, 1 to buy, 2 to sell. So even though you may not be on the loan, the lender may say, let's put her in the contract so we can get her in the deed, because they know even though you're not on the loan, they still need you to sell. So they're going to want you in the contract probably. They're also going to want you on the deed. Remember that girlfriend that I helped buy the house and they had stuff in the attic? Her and her husband needed a cosigner. Her dad and mom helped her cosign. The lender asked me to redo the contract to add their names. So now I don't have 2 people on the deed. I had 4. And that was a lender request. And it's becoming a very common thing. And as a matter of fact, it's so common. We've already looked at this form, but I want to go back and pull out something. Remember our agreement to amend? And again, just last July, this was added. We can amend the contract to add an additional buyer. So the lender comes back and says, we want to add Kara. We can now use the agreement to lend. The lender comes back and says, we need the cosigner and their spouse. We can now use the agreement to amend. So this is, again, coming up often enough that we now have a provision in a form for that. Let's take a break. 7:12, 7:22, 7:23, 10 minutes, 7:23. Take 10. Just started raining here again. I thought we were done for the day.
Oh, we got a week left of rain from what I've seen.
Well, that's not really what I just wanted to hear right now, Gabe.
I'm sorry.
Dang. We're in for, I guess I knew that. I'm just trying not to.
Who knows? Who knows? Maybe the mountains will catch it for us this time. I'll be the
Easy,
optimistic weatherman here.
easy, Gabe. You're forgetting where I'm at.
Where in
He's
Wilkes
at
is
the
that?
foot. He's the one catching it.
Oh yeah, yeah. Well,
Your
Thank
Saul's,
you, Jeffrey.
I think. Aren't you in
Sorry.
Winston?
say
Kara's
what?
in Winston. Yeah, Kara's in
Yeah,
Winston.
I'm in Winston.
Yeah, it
I'm
rains
right on the Winston-Louisville border.
today, Wednesday, Thursday, and Friday.
Just
It's
rain,
rained like every day this week.
rain, rain. It'll make us appreciate the sun when it comes back out. Yes.
That's true.
I don't think
That's
it's
very
supposed to be
true.
like in the 50s though after today.
No.
It's annoying for me to let the dogs out because Titan wants to go on a field trip, which gets those big old fuzzy paws of his wet. Spirit, she's right
Oh,
here.
my dog's the opposite, won't go outside in the rain. He doesn't like getting his feet wet.
Aw, poor little thing.
Like he waits until the very last second to be like, I really gotta go. Did it stop raining?
Does not leave
There
my
he
son.
is. That's awesome. That's great.
Gotta love her.
He went back downstairs.
Titan, I don't know where he went. Titan. Come here, buddy.
That's when you have to worry is when you don't know where they are, right?
My children, yes, because apparently he colored crayons all over his walls in his bed.
This one's a beast.
Oh my.
I know what we'll be doing tomorrow, scrubbing walls and furniture and toys.
He's an artist.
He did. He drew like a person and like it was an action. This is I mean, better than the last time when they drew circles all over the wall. So, but
Funny. That's
It's
funny.
passion on paper next time. Yeah.
I said, where do crayons go?
He's a
Well, he's like, I
prodigy.
didn't know that they were crayons. I was like, okay, good try.
Dang. Always fun. You never know with pets and kids, it's always an adventure, right?
It is.
And adults too. I mean, what the heck? I don't know why I'm limiting it to kids and pets. You
These
never
guys,
know.
they wake me up. Okay, if I fall
I did
asleep
have
on the sofa,
I-
5 o'clock, Titan's over there on the sofa with me with his head looking down at me. That's what I wake up to. And go outside and pee, but it's like on the money.
I did have a question. I
Yeah.
couldn't remember if I didn't remember if I read it on the personal prop or on the fixture stuff. So, like, if you're in city limits, trash can, like the trash cans and stuff, are those in the contract that they stay?
I don't believe the totes are.
They're owned by the company that picks up your trash.
Yeah, so
Yeah,
that
but the
should
city has
something
the
that-
city gives them to us,
so I think that's one of those
or you buy
things.
them from the city.
I mean, it's just kind of, you're right. It's not in the contract that they're supposed to leave totes. You know, the provide them, and it's kind of, and I hate to use the word implied, but it's implied that the seller will leave the totes. But you're right. So maybe we need a court case before those show up in the contract one day. You know, I don't know
I
why
mean-
somebody would move and take the totes. Ew, you know, but
We had to buy the yard waste totes, and they were like $80 a yard waste tote. We
Yep.
have the X.
And I know we get emails from the city every once in a while. We can replace our totes for a small fee of, and I'm like, wow, as long as it's still getting tote from the house to the street, I'm like, I don't need to replace anything. Thank you for the offer.
They'll
but no,
replace
I'm good.
they'll replace the lid if the lid is broken for free. You just email them your address and they just come out and do it.
Go. And we know each city, county, they're all a bit different. But yeah, that's one thing, you know, maybe on your buyer's checklist, you know, hey guys, let's make sure the totes are there. But you're right. That's one of those things. It's just not, in the contract yet.
I don't own my totes. The company owns it.
So each city and county and municipality is going to be different. I mean, we're 4 different cities here, so we're all going to have 4 different sets of rules,
I'm in the county. I'm not in the city.
Different. Okay, then we're all different counties and we're all going to have different sets of rules because they're all different.
Yeah, I had a lady in the office today complaining that their taxes were going to stay high since they doubled it in here. And so, I told you mine are staying the same in the county. So I'm glad I don't live in the city.
That city. Yep. Yep. And that's the thing, you guys, I can tell you all about a lot about City of Archdale, but what's that mean for my buyer buying in Trinity? Right? I mean, you unless so our best bet is to get them to, especially with these specific questions. And again, on your buyer's agent checklist, listing agent too, you got to leave the totes. Tell the sellers it's kind of implied that they're going to leave the totes.
I'm glad I'm hearing this because it's giving me more things to think about when I am talking to the individual. What goes, what stays, and the rules are different for different areas. So this is good to hear, actually, I think.
And
I
Jeffrey,
know when we lived in Missouri, you had to buy your own tote. You didn't
Mhm.
they didn't provide any. They were like, just put whatever tote you want out.
Yep. And this is why when we say real estate agents are the experts of their market, I mean, I'm familiar with the area. I can tell you where the subdivisions are in the streets, but it's more than that. It's knowing where to find the information, knowing who to, where to go for the city or the county, where to find zoning information, where to get this stuff. I don't have Randolph County zoning map memorized, but I do know where to get that information. I do know if my buyer were to say, well, how do I get totes? I do know we call the city. You know what I'm saying? Knowing enough to know to help them get that information, knowing where to go. And that's a huge part of it.
I
So
think
we're
my
still,
company my firm gave us there's a service too that you can use that will like literally do it all for them. Like you can say they'll do this for a fee and they'll set it all up and
nice.
go down the list.
I mean, it's a lot. We've moved before. Moving sucks. They say that for a reason. Why? Right? Because it's not just a matter of putting your stuff in boxes and getting on a truck. It's a matter of cutting off and turning on and, all those arrangements in between. So, yeah, that's why I'm such a big fan of checklists. One, they make sure that I'm telling my buyers and sellers the same thing every time. But 2, I'm just in general, and fair housing teaches us what we do for one, we do for all. So if I have a checklist that I work with every single buyer, it doesn't matter. I'm ensuring that I'm doing the same thing for all and ensuring that I'm giving everybody the same service and treating everybody
Have you got a checklist that you've created
over the years.
over the
Yep.
years?
Yep. I mean, we've, something happens, we add to it, we delete it, it gets, updated. And check with your firms because they very well may have like a template to help you get started, and then you'll find that you will tend to make that your own, that you will kind of create that. But just using the listing agreement, the contract, the buyer's agency agreement, using them as checklists to make sure that we talk about everything, that we have these conversations. Pre-pandemic, we used to put buyers in our car. We'd go out, we'd spend all day with them, or they follow us around and they'd spend all day. We'd go look at 10, 15 houses on a Saturday. That's a lot of houses to look at one day. And I got to tell you guys, once I got to know them, that's the key. Once I got to know them a little bit and I trusted them, I liked putting buyers in my car to view multiple properties because it gave me the opportunity in between to talk about things like due diligence fee and earnest money deposit and these things that are coming up in the contract. Today, everything just happens so fast. We're so fast. We're in a swift market. We're in a very swift moving market, but that doesn't negate our responsibility to explain things such as due diligence fee, earnest money deposit, and these other various things in the contract. So finding time for those conversations. All right, sellers' obligations or responsibilities. We are on sellers' obligations still. Seller has an obligation. Agreement to pay buyer's expenses. Seller shall pay at settlement X amount, if any, toward any of the buyer's expenses associated with the purchase at the discretion of the buyer lender, if any, including any FHA, VA lender and inspection costs the buyer is not permitted to pay. Remember we talked last week about not leaving a blank blank. And this is a blank that we definitely need to make sure we're putting something in. Isn't 0 a number? No matter how much the seller, if any, how much the seller agrees to pay of the buyer's expenses, if they say, no, I'm not paying anything, that we need to indicate that in this blank. We need to make sure everybody is on the same page with how much, if any, the seller's going to pay of their expenses. It was not my agent, but we got an offer from an agent, and it was like 3% of loan amount or any amount. I mean, it was it was all kinds of just wording. Specifically, what is that blank asking me for? Is it asking me for a description or an explanation? What's that blank want? Give me a number. Give me a number. And my agent sent it back. So this is not how we properly complete the contract. Make sure that we're properly completing it. When it wants a number, a $sign, that's specifically what it's asking for. It's not looking for the side story, which is pretty much what this agent gave us. There's a blue note there. Parties should review the FHA VA addendum prior to entering an amount. In this paragraph, certain FHA VA lender and inspection costs cannot be paid by the buyer at settlement, and the amount of these should be included in the blank above. So again, it's referencing our FHA VA financing addendum, which we will look at. This one form we'll talk about. In the event of a VA specifically, for example, the VA will require the pest inspection, but very rarely will they let the buyer pay for it. Which means if the seller's accepting a VA loan, even if they don't agree to pay any other of the buyer's closing costs, we need to have the amount of the pest inspection in here. We need to have the amount of those required inspections by the VA. So that's what that note's telling us, that they should be included in the blank above.
But you can't put that amount in until you know how much it is.
So you're communicating with the lender, and we have an idea. We have an idea, because I'm quickly writing this offer up, right? So I may not be able to call my guy and say, what are you going to charge me for a pest inspection, this address? But we can put in a pretty good idea, a reasonable idea.
What would you put in there?
It might depend on where I'm at, right? So, you know, different costs, different home inspectors have different costs. So, you know, I would go to my go-to home inspector, or one of my go-to home inspectors, depending on where it is or who's going to do it. It's hard to get an exact amount.
But you can't put plus or minus $300.
Correct. We need an exact amount. The other thing to keep in mind, you guys, is that let's just pretend for a second. Let's just pretend that the seller is willing to pay. I'm making numbers up. The sellers say, I'm going to pay $2,000 in the buyer's closing costs. Okay, we've come to this. We've agreed to terms on this. If there's a VA loan, the seller's going to be responsible for paying the VA loan. So part of that $2,000 will be, not the VA loan, I'm sorry, for that pest inspection. So part of that $2,000, in other words, all of that $2,000 won't go to the buyer's closing costs. Some of that will go towards the pest inspection. So if you want to make sure you get $2,000 and the pest inspection, then we may need to do something that looks like this. So now the buyers get $95. I made a number up. Now the buyers get $95 for the pest inspection, and they're getting their $2,000 in closing costs for other fees. The other thing I need you guys to make sure, the FHA and VA loans, specifically those two loan products, often have limits on how much the lender will allow the seller to pay. for closing costs. Sometimes it's a percentage of the loan amount. Sometimes it's a flat amount. Each product is different. So before we fill out this line, it's advised that we talk to the lender. You know, under this loan product, my buyer is getting this loan product. What's the max the seller can pay? If I put more in here than what the lender will allow, then the difference is going to come out of the buyer's pocket. Do I have a happy buyer? Absolutely not. So it's worth the call to the lender. It's worth this conversation if there's any of those seller pay closing costs. This is something that went away with the crazy pandemic house market. But we're starting to see it come back. And actually, we're starting to see sellers agreeing to pay X amount towards the buyer's closing costs. So again, just making sure that we have the lenders okay. I mean, I would hate to put my buyer in that situation where they found out that the seller wasn't able to pay everything that they agreed to. If the seller can't do it, it's got to come from somebody, right? In this case, it would be the buyer.
I know we don't put our commissions on there. They can't put the buyer's commission, if they're agreeing to pay the buyer's commission, that's not a buyer expense that you're putting on there, correct?
Correct. This is
Although
specific.
that may be changing.
Yep. I got another form for that. It's form 220, cooperation of compensation, roughly is what it's called. Because to your point, Carrie, remember, big picture, we don't belong in the offer to purchase and contract. But specifically, I can't make any mention of my commission. This is buyers pay closing costs, not buyers agents commission. Yep. Owners association fees and charges. Seller shall pay any charges by an owners association or management company vendor as agent of the association under paragraph 9A of this contract. We'll see that in just a second. So again, back to those HOA charges, if any, transferring from one owner to the next, setting up the new account. Some of those charges we may just have to, and the attorney's involved. The attorney's the one communicating directly with the HOA. Payment of special assessments. Special assessments again. Seller shall pay in full at settlement all special assessments that are approved prior to settlement, whether they're payable in a lump sum or future installments, provided that the amount can be reasonably determined or estimated. The payment of such estimated amount shall be the final payment between the parties. So again, anything that's approved prior to settlement will be the responsibility of the seller. Anything approved after settlement is the responsibility of the new owner. Good rule of thumb, who owns it when it's approved? And that's going to be the one responsible for those special assessments. And also whether payable in a lump sum or future installments. The little condo I own, the complex was built early to mid 70s. So it's getting on up there in the years. And it just seems like within the last couple of years, we've had to do new roofs, new vinyl sidings, new parking lot. I mean, we've just gotten all sorts of things in the last few years. The HOA said, here's the special assessment. This is what you guys owe. I said, oi. But they allowed us to take that payment, divvy it up. I mean, for like twice a year for like 4 years or something like that. That would be the future installments, right? So they want the seller to pay everything due as part of their proceeds, so they don't have to go to the seller after settlement. So even if they do work up those future installment payments. We got a new, it's either a 10 or 12-foot fence around the pool. We got key fobs for the pool. We've had some major upgrades in my little old condo complex. It's good to see money being put into it, even though some of it's mine, but it's still good to see money being put into it. It needs some updates. Late listing penalties. All property tax late listing penalties, if any, shall be paid by the seller. Late listing penalty would be, for example, if the seller never paid 2024 taxes, 2023 taxes. The seller's responsible for those as part of their proceeds, and it'll show up on the title search that the attorney does as well. Negotiated repairs and improvements shall be made in a good and workmanlike manner. And again, buyers shall have the right to verify that they were made in that good and workmanlike manner, same prior to settlement. Home warranty. We're told to select one of the following. No home warranty is to be provided by the seller. Buyer may obtain a 1-year home warranty at a cost not to exceed X amount, which includes sales tax, and seller agrees to pay for it. Or seller has already obtained and will provide a 1-year warranty from this company at a cost of X amount that includes the sales tax and will pay for it at settlement. I like that they have the verbiage here, a cost not to exceed. Because Jeffrey, to the point of your earlier question, how do we know how much it is? Well, we probably know the home warranty. I can probably get a quick quote, but in negotiating, I may not know that amount. So let's just say I'm making numbers up. Let's just say I put $1,000 in here. That's a big home warranty, but I put $1,000 in here. If we order the home warranty and it comes back at $650, that's all the seller is on the hook for paying. Because this is a cost not to exceed $1,000, but they're only going to be on hook for the bill, for the invoice. I would not put 1,000 in there. That was just a number I used for an example. Head bobs, everybody just. Well, Julie told me to put 1,000, and no. That was just an example.
You finding buyers now wanting a home warranty or even insisting on a home warranty?
They're coming back. They're coming back for several pandemic years. It was almost a joke. It was funny if you said home warranty, but we are starting to see it come back. It's becoming that point of negotiation again. So I saw one that came across my desk the other day. In lieu of repairs, the seller agreed to provide the buyer a home warranty. So it's that round 2 or 3 or 7 of negotiations, wherever we are at this point.
I found those things to be useless. My double oven went out last year in June, and they monkeyed with it all the way until the end of November, and then told me they weren't going to cover it. Get this. They thought that the racks were left in the oven whenever you did the self-cleaning procedure, and that voided warranty. And I had the racks. I mean, no. They got out of $2,000 right there, and I canceled my home warranty after that. I said, screw this. They already did it on the hot tub, the well, and the double oven.
I'm sorry. I do know there are good success stories. I'm sorry you had that experience. I've heard other stories come through. So maybe, shop around home warranty companies. Again, your firm may have one that they've used. I will say this, you guys, do your research, because there's a lot of new home warranty companies out there. And my concern with new home warranty companies is we don't have a payout history. So without that establishment, we don't know what they may or may not. Again, there's conditions apply, but we don't know what they may or may not pay out.
Get this. If you had a hot tub at your house, okay, all 3 of you there, if you had a hot tub at your house, where would it be located? Where would it be located? How would it be positioned around your house? I know I'm being vague on that, but there's a reason behind it.
Okay. So
would you have it sitting outside like on your deck or like in an enclosed sunroom? Would you have it in the ground? More likely, which one of those scenarios would you do?
Stay off the deck.
Okay. I like that. Deck. Okay.
Outside.
They would not cover mine because it was not in the ground.
So again, there's different conditions, and that's where there's just different conditions. Each company has a different condition.
It was insane. I mean, I bet 90% of the people have them above ground, but they don't tell you that until you say something.
You're saying it wasn't in the brochure?
I specifically told them that I had a hot tub and listed that as additional expense, to the contract, that it was sitting in a sunroom in my house. And they said, no, because it's not in the ground, it's not covered.
So to that point, we got a blue note here that's reminding us home warranties typically have limitations on and conditions to coverage. So refer specific questions to the home warranty company. Again, I'm sorry that you had that experience, but please don't let that deter to your buyers, right? If the buyers want a home warranty, then we can advise them, we can recommend them a home warranty company, let them decide if they want to purchase that home warranty, not based off of that experience. You don't have to recommend that home warranty company, but I would not recommend any home warranty company because of that one company.
I say now if the company that's offered when you buy like a washer dryer and you get the extended coverage through them, if they offer a home warranty program, they may be something to look at, because our dryer went and it was the most expensive part, and I bought the coverage and they came out, we had the parts delivered and it was repaired within like 4 days of it happening. So
Nice.
I mean, there are some good companies out there that will do what they're
Agree.
supposed to do. And like they
Absolutely.
literally diagnosed it over the phone.
Nice. Nice. I think a lot of times for buyers, it's just peace of mind. I'm buying this new house and I don't know how stuff does or does not work. So if we can negotiate that, or they can get one on their own, the seller doesn't have to pay for it. It just wouldn't be part of this agreement.
My husband's like, you actually did something correct. When I bought the extended coverage, because I was like, I think every dryer we've had that happen, and it normally happens outside the warranty. So,
Right. And that's usually how it goes, right?
Mhm.
Okay, last thing in seller's obligation, their breach of contract. And we're just instructed to see paragraph 23 for buyer's remedy in the event of breach of this contract. So we're getting there. Charges by owners association. Responsibility for payment of charges by an owners association or management company, vendors, of agent of the association shall be allocated between buyer and sellers as follows. So again, the parties are agreeing who's paying for what. Seller's going to pay any fees incurred by the seller in completing the RPODs and resale or other certificates related to a proposed sale of the property. Seller's going to pay any fees required for confirming the seller's account payment information on an owner's association dues or assessments. Seller's going to pay any fee charged for transferring or updating ownership records of the association. Seller's going to pay any fees other than those specifically required to be paid by the buyer under 9B below. 9B below tells us that the buyer is going to pay for charges for providing information required by the buyer's lender, charges for working capital contribution, membership fees, or other charges imposed for the buyer's use of the common elements or services provided in connection with the buyer taking possession of this property, such as move-in fees, and the buyer's charges for determining restrictive covenant compliance. So at some point in the transaction, your buyer or seller may look at you and say, well, what am I supposed to pay for charges for the owners association? And it's all right here. It's all spelled out for us. Again, we got the attorney communicating directly with the closing, with the HOA, and making sure that all this is handled, all this is processed. The seller may have, we talked about late listings. The seller may have outstanding HOA dues. That expense would also be borne on the seller. The buyer's not going to take any responsible for late things that have not been paid.
Does like HOA given items, like we have a key card for our swimming, like you said you had a key card for your pool too, it got updated. That's part of stuff that needs to be left behind.
Yeah, however that's worked out. When the HOA, when they notify that I'm not going to be the owner anymore, they may deactivate my fob and give a new one to the new owner, you know, probably what they do, but however that's going to work out. And the attorney would just kind of let us know.
They just left us our key card, and I think we had to sign something before it was reactivated. So
And if I were going to do that, I'd want my name off it. You know what I'm saying? I'd want to make sure that they transferred and I was no longer, because as the owner, I mean, I got a tenant too. My tenant has a fob and I have a fob, but as the owner, I'm responsible for all of us, you know? So just making sure that my name's not attached to that if I'm no longer the owner. Prorations and adjustments. We talked about prorations. We did some prorations. Unless otherwise agreed, the following items shall be prorated with the seller responsible through the day of settlement. So the contract tells us that the seller is going to be responsible for taxes, rents, and HOA dues through the date of settlement. Seller entitled to the amount of prorated rents to the date of settlement and either adjusted between the parties or paid at settlement. And then we get into a list of things that may or may not be prorated. Almost always going to have taxes. You know, I can't imagine a scenario or situation unless closing is December 31st. That could be the only time that I could think of that we wouldn't have to prorate this year's taxes because the buyer would own starting January 1st, right? So that would be the only time I can think of, you know, December 31st. Otherwise, we got to share this year's taxes. Taxes on personal property. This is if buyer and seller agree to personal property and outside bill of sale. So I can't tell you how many times I've been shown property and we walk in the garage and see some nice car in the garage. I don't know cars. I see a car and I tell you it's red or blue or whatever. You know, that's my extended knowledge on cars. But we walk in the garage and my buyer's like, oh, look at this big fancy car. Does the car come with the house? To hurt. And you know what I always tell my buyer? Anything's negotiable. If you want the car to come with the house, then money talks. Well, obviously they don't. They're just talking, right? But what if we did negotiate that car or the boat or the RV or, you know, whatever other personal property item? If that personal property is taxed, then those two parties will prorate the taxes on that personal property item. Remember too, if we do negotiate the car does not go in the offer to purchase and contract. We have a form for that, and we can use, it's called an outside bill of sale. So any personal property that's not getting listed, all personal property that's not getting listed on the contract, like the refrigerator and washer and dryer, anything else can be used. We can use that outside bill of sale. Rent, if any, and then of course any HOA dues. So it spells out the prorations. Condition of property, risk of loss. Condition of property at settlement. If the property is not in substantially the same or better condition at closing as on the date of this offer, reasonable wear and tear expected. Buyer may terminate this contract by written notice delivered to seller. The due diligence fee and earnest money deposit shall be refunded to the buyer. If the property is not such condition and buyer does not elect to terminate this contract, buyer shall be entitled to receive, in addition to the property, the proceeds of any insurance claim filed by the seller for those damages on the destruction of the property. This is about the most vaguest paragraph we have in this contract. Define same or better condition. In the extreme, we're talking about the house burning down or a tree falling on the house, total destruction. We're talking everything from something that wasn't broke and now is, or total destruction of the property and everything in between. Bottom line, If the property is not in the same or better condition as on the date of this offer, reasonable wear and tear expected, the buyer's got two choices. They terminate and get their money back, or they don't terminate, they get the property and they get the seller's claim.
Is this something that your water heater buyers could have used?
Well, they would have to prove that
Same or
it,
better.
they'd have to, this is what's getting, this is what is hard right here. They would have to prove that it was broken at the time of the offer, or that it wasn't broken, excuse me. They'd have to prove that it broke after the time of the offer. You know what I'm saying? Same or better condition is what's going to get you. But if you can prove it, if you can prove that it wasn't that way at the date of this offer, it's really, really vague. Very, very vague. Can we agree? Because it's covering every situation in between. Bottom line, you guys, if the parties can't agree to agree, don't encourage anybody to sign until we get this worked out. I'd have both of my people talking to their attorney. I mean, even if it's clear the house burns down and there's nothing left to sell, it's pretty clear, right? But the buyer still has a choice. Do I, not terminate, or do I terminate and get my money back? Buyer's agents, your buyer's going to look at you and say, well, what should I do? You know what I'm going to tell my buyer to do?
Talk to their attorney
Talk to their attorney. Talk to
or
their
the
attorney.
loan company, because they're probably not going to get a loan if the house burnt down.
Or the lender. I would even, if they're thinking about this, I'd have them communicate with the seller's insurance company, right? I'm going to have them talking to some people and making some phone calls before they make a decision.
Well, their insurance would rebuild the house. You could get a brand new house out of it.
You get a new
Depends
house, and
on-
if it's the location you wanted, you get a new
It
house.
depends on the insurance policy too, though, because if they just have,
Yep.
depends on how the payout is for the insurance policy, because they may not get the same house. They may not have enough money to get that same house.
They may get a tiny house on that big old lot, right? For example. So again, we got the buyers talking to the seller's insurance company. We got them talking to attorneys. We got them talk before they make the decision, you guys. I believe if the house burns down, I don't know. What do y'all think? I think most buyers would say, moving on, give me my money back, and I'll go about their lives. I agree. But again, what if it was the location? What if it was just, what if, So it's not my job to tell you what to do. It's my job to explain what the contract says and to advise you to talk to your attorney, to advise you to talk to the seller's insurance company if that's the route you're thinking of taking. Jeffrey, did you have?
No, I said, like out in California with all those houses overlooking the bay and stuff like that, and you're under contract or whatever, you might still want that piece of land to build your house back the way you want it. So, I mean,
yeah. Hey, let's bring this home. Do you not think there were homes for sales in the mountains when Helene hit? This could happen, right? Right? This could happen. You don't know, but it very well could happen. And the real estate piece of the mountains was one thing that not many people heard about. There was, real estate transactions going on when that happened. So this paragraph very, very well may have come into place during that time. What does the contract say? And what the contract says is it gives the buyers options. And like I said, you guys, your buyer's going to look and say, well, what should I do? Well, just give me your opinion. I promise I won't hold it against you. Oh, no, absolutely not. Because again, I'm not the one buying this house or not buying this house. Are you guys with me? It's not my job. My job is to give them the information that they need to make an informed decision. Talking to an attorney allows them to get to an informed decision. Talking to the seller's insurance company allows them to get to that informed decision.
That'd be interesting talking to the seller's insurance company since they're gonna have to probably have permission to talk to them.
Mm-hmm. Mm-hmm. And let's face it, we know homeowners insurance companies are not known for their rapid payouts. So is closing being delayed? If the buyer wants to continue, there's a good chance that that's going to be delayed because we got to get all this worked out before they sign.
Well, like my insurance policy, if my house burnt down and I still owe the bank for whatever I owe it for, the insurance company is not going to write me a check for $750,000. They're going to say rebuild the $750,000 house. You know, it's what they're going to do, and so
Yep.
that
So
can come into play as well. What they
But
require.
rebuilding a $750 house may not be what it is today versus what it was when you bought the house. So like $750 may not get you as much house as it did previously due to the cost of building materials and so forth.
Depends
So
on
that's
the
where
some
that comes in.
is replacement. You know, so if I paid 500,000 to build it, but it costs 750, my insurance policy will pay 750. It'll pay for replacement cost, but it's got to be the same. You know, you can't go and start changing things up.
right. So there's a lot. And I think that's what we're all hearing. There's a lot, all the what ifs, you know, and all the different policies and just the different buyers and situations. So this is what we know. This is all we know. And then we talk about risk of loss. The risk of loss or damage by fire or other casualty prior to closing shall be upon the seller. Sellers advised not to cancel existing insurance on the property until after confirming recordation of the deed. Listing agents, it's worth mentioning to your sellers that they got to keep utilities and insurance through closing. What does the contract tell us? Y'all know how many times I've gone under contract? Congratulations, seller, we're under contract. I've had two now say, sweet, I'm going to cancel homeowners insurance. Hold up, hold up. It's still your house. Even though somebody's under contract to buy it, it's still your house. And guys, I don't understand that the average public doesn't know our verbiage. They don't understand our speak. And so when you tell somebody that it's under contract, they may interpret that to mean that it's sold. You and I know when it's under contract, it's closer, but it's not a done deal yet. So listing agents, it's worth it in your listing presentation. It's worth it when you're talking to sellers. You need to keep utilities and insurance through closing. And that way we don't have these issues. Because if the house burns down and the seller doesn't have coverage,
I
what do you
think
do?
our insurance adjuster required us to have something from the attorney showing that the house was sold, like before they canceled it.
Nice. I like that. I really do like that because they probably have been in this situation before. House burns down, so I was going, well, I'll have insurance, you know. So it's just worth that conversation. And again, buyers are getting a brand new insurance policy. Their policy is going to take effect the day of closing settlement. The seller's is going to end. Now, the home is not doubly insured. Remember, there's a date timestamp that the deed records. And if the house burns down on closing day, I have a feeling the insurance companies are going to want to know what time did the fire marshal say the fire started and what time did the deed record? Because they're going to need to know who owned the property that day at that time to know whose insurance to hit. So we're not doubly insured. The seller's is ending and the buyer's is immediately starting. Does that look shady if the house burns down on closing day? I
Not
would
at
think
all.
so. The fire marshal's got a big investigation on their hands, don't they? All right, let's see. Let's take a break. I got 8:07, 8:17, 18, 10 minutes ish. All right, let's take 10. And there's your little fur baby. You're on mute.
He's limping, so
Oh,
it's
it's the one that doesn't like to go out in the rain.
correct. I think he's been
That's
a
what-
total of 3 times today.
That's why he's limping, because he thinks if he's hurt, he won't have to go outside.
Quite possibly.
I dog sat for a lady many years ago. She had 3 dogs, and one of them would not go out when it was raining. So much so that she had to keep a kiddie pool in the garage for this dog for when it was raining. I was like, oh no, no. If it's got to go bad enough, it'll figure out how to go in the rain. You know.
I have a friend that would go with like an umbrella and like hold it over their dog, and I'm like,
Nope.
no, he's gonna figure it out.
Nope, he'll figure it out. You know what they do?
He's looking at you like, excuse me?
I didn't make a friend, did I?
No, he figured it out. I tried to let him out this morning first, and he was like, stuck his head out. Was like, it's raining.
Are you sure?
And then he barked when he like an hour later with the kids. So they let him out.
That's funny. Is he the same way with the snow?
He loves the snow.
Isn't that weird?
Complete opposite. Loves it. Runs around like he's a kid in a candy store.
That's so funny. That's just wet rain, bud. Or cold
I
rain.
was gonna say
Frozen
earlier,
rain.
Jeff, I did notice that you had a new shirt on.
Changed.
I looked in my wardrobe. It turns out that I'm serious. I do not have a single black long sleeve shirt.
Wow.
I don't know how,
I still got
but
my. I had to put this on because it's cold out there in the rain. The temperature now's dropped. It's snowing at my house, but
No.
it's 53 now. No,
I was about to say,
brother, that was a joke.
there's no way.
But
I was
she
getting ready to log up, pack out, and move. That was the case.
afraid I'll shut the door on her, so she'll stand there until I walk out into the grass, so she'll go pee. You know, she don't want to be separated from me. So the things you do for your German shepherds or German shedders.
We do for all of our 4-legged family members, right?
Uh-huh.
He's talking about an umbrella. My mom's got an Alaskan Eskimo, and she's so particular. You do have to walk out with an umbrella for her to pee, and she will cock her leg as opposed to letting her little special spot touch the grass. I mean, she'll do everything she can to keep from touching
That's funny. That's funny. Their own little personalities.
She does.
All right, let's see. Wrap this thing up. Chucking right along. I got a delay in settlement. This is going to apply if one party is ready, willing, and able to complete settlement. They're going to be referred to as the non-delaying party. But it is not possible for the other party to complete settlement by the settlement date. They are called the delaying party. In such event, the delaying party shall be entitled to a delay in settlement and shall give as much notice as possible to the non-delaying party and closing attorney. If the delaying party fails to complete settlement within 7 days of the settlement date, and this includes any amendment to the settlement date agreed in writing by the parties, then the delaying party shall be in breach, and the non-delaying party may terminate this contract and shall be entitled to enforce any remedies available under this contract for said breach. So we got one party that's ready, willing, and able, and then we got another party that for whatever reason can't close on time. The delaying party, let's just run a scenario. Let's say the delaying party is the buyer. And the reason they're delaying is because we don't yet have loan approval. We're close, but we don't have the final clear to close from the lender. That makes the buyer the delaying party and the seller the non-delaying party. The seller, as the non-delaying party, has no choice but to sit still and be patient for 7 days and hope that we get that loan approval. If the seller if the non-delaying party terminates within those 7 days, they will be in breach and they will suffer their consequences of breach. They sit still for 7 days. On day 8, if we're still not closed, now the non-delaying party can terminate. The delaying party will be in breach and they will suffer those consequences. We're going to spell out both parties' consequences of breach.
Do weekends and holidays come into play?
When you're talking in contract speak, yes, a day is a day. And we will define that later so we know and we're not implied. So yes, a day is a day. We got a 7-day delay built into our contract. I gave the example of the loan approval because that's a common reason why that we may have a delay. I mean, if the buyer doesn't have the funds, then they can't buy. I think another common reason for delay is if any agreed upon repairs aren't complete yet. The seller says, sure, I'll do the electrical, but they call their electrician and they're booked out until next week. There's only so much we can do about certain things, right? So what I say to you, especially as we're getting down to near the end, please communicate with the other agent. If your party might be in a delay, if they might have something come up, just communicate with the other agent. Don't let anybody thinking they're going to show up that day to close when you know that your party can't. I do want to, while we're here, because this is talking about including any amended settlement date agreed to in writing by the parties. So while we're here real quick, I do just want to go back to our agreement to amend, because if we did have to change the settlement date, then a good place to do it would be on our agreement to amend the contract. And as we look down here, we can see that we have a place for a new settlement date if the parties agree. So maybe the repairs are going to take longer and they say, well, let's just agree on a new date. Maybe, whatever reason, we've decided and agreed to a new settlement date. We use the agreement to amend. Once we change the date, then we still have a 7-day delay from the amended date, unless we check this box. If we check this box, we have the new date, and now we only have a 4-day delay. So check the box. I got a 4-day delay from the new date. Don't check the box, and I got a 7-day delay from the new date.
Okay, can I ask a question about settlement dates in general? So if you're writing out this contract and stuff, you're going to have to talk to the attorney before you set a settlement date, correct? You don't arbitrarily say 30 days from the day you sign that, we're going to have settlement.
So usually what happens is we'll agree on a date. And as soon as we have a signed contract, because we're at least 30, 45 days out. So as soon as we have that signed contract, as soon as we agree the date, I will call the buyer's agent, will call the closing attorney and get settlement scheduled. So we're not like preliminary on the books, but we do want to book it soon because we know this is the date that we agreed to.
So does that mean that probably there's going to be an amendment to this contract?
If the attorney can't close on that date, but they can close the next day, then we got that 7-day delay built in. See, we got some wiggle room there, right? Right.
Okay.
I mean, it's not my fault if I wanted to close on Wednesday the 5th and the attorney's not available till Thursday the 6th. But
Okay, it makes sense. Thank you.
We can't get it in the books until we know for sure.
Right. Okay.
My realtor also, like, I think you get used to your closing attorneys that you use, so you know what they are good with. So you're saying, like our realtor, when she was writing up her contract, she figured out all the dates because she's like, okay, we're going to use this guy. They typically close in X amount of time. Like, it's just something that you learn with time, I think,
Yep,
and
yep.
who
So
you're
you
used
use,
to.
you know, the same, or you use one of the three same lenders and one of the 2 or 3 closing attorneys and home inspectors. You get an idea for how they work and what their timeframes are. Yep. And Jeffrey, if say no, we're going to change attorneys, then I got a place up here to change that escrow agent, which would also change who's holding the earnest money. So if the settlement agent isn't available, you know, to Kara's point, if you're trying to get on the last day of the month, the attorneys are super busy the last day of the month. Everybody's trying to get closing in the last day of the month. So if we have to change it specifically with the escrow agent, then I got a place to do that in our agreement to amend.
Okay.
If I had a buyer that needed a quick close, like we're going to a cash buyer, maybe 2 weeks or something, then I would probably call the attorney and say, hey, can you get us in by this date? You know what I'm saying? Because that would be an unusual circumstance. A 2-week close, for example, I'd probably call my attorney or the one we're going to use. But usually we're, 30 to 45 days from contract to settlement, give or take, depending on the market.
I mean, if they have cash, I'd hope that maybe they know an attorney in the area too.
Maybe. New to the area, they're bringing their investment game to a new market, So delay in settlement, I got a 7-day delay built in. And the whole reason it built in is because delays just happen. I mentioned it last week. I'm very, very adamant about it. But I always tell my parties, buyers and sellers, to have a plan B. Everybody's working as hard as we can to get this done on the agreed upon settlement date, but things happen. So in the event things happen, just have a plan B. Possession, including all means of access to the property, transferable amenities and services, keys, including mailbox keys, code, including security codes, garage door openers, electronic devices, etc., shall be delivered upon closing. Y'all don't give your buyers the keys at settlement. It's not theirs at settlement. It's not there until that brand new deed records. And the contract is out protecting the seller to make sure that those keys, those access, those means to the property are not delivered until closing. So we go to the attorney's office for settlement. We all do our thing at settlement. And then usually we leave the attorney's office. And sometime later that day, fingers crossed, you're going to get an email from the attorney or the paralegal. And it's short, sweet, and to the point. The whole email says, we are on record. And that's how you know it's a done deal. That's how you know you can give your buyers your keys. You can go back and get your check. Your seller can get their proceeds check. That's how we know it's a done deal. So possession is defined as closing unless otherwise provided below. So we may have a case to use a buyer possession before closing, a seller possession after closing, in which cases we got a form for that. We'll briefly look at both of those forms. Or possession is subject to right of tenants. Parties should either attach their additional provisions addendum or the vacation rental addendum. So maybe the buyer's already living there as the tenant, in which case possession has already happened. But unless we use one of these agreements, otherwise the keys shall not be delivered until we get notice that it has recorded. Then we have addenda. Check off standard addenda that may be part of this contract and attach it here to itemize all other addenda this contract, if any, and attach. So throughout the contract, we've seen various times that we may need an addenda. What this does is gives us a nice little handy dandy checklist to make sure that we have all applicable addenda, anything that relates to this transaction. You can see here, I also have a place to add an attorney or identify other attorney or party drafted addenda. I can't touch a pen. but the attorney can, my buyers and sellers can. They may come to terms, one of them drafts it up, one of them can sign it, and we've attached it here. So all we're doing is letting everybody know which addenda are going to apply to this transaction. And in case we forget, there's a blue note, all caps, under North Carolina law, real estate brokers are not permitted to draft addenda to this contract. I'm actually kind of glad it's here in the contract, because sometimes buyers and sellers ask, can't you just add? Can't you just, and it's not just me talking, it is legit. I cannot draft. There's a blue note in your contract that tells me I can't. Assignments, first off, what is an assignment? An assignment, you're transferring one's rights, responsibilities, and liabilities to another party. With an assignment, the only thing that changes is the name of one of the parties. Any good contract is going to address whether or not it can be assigned. So R2T says this contract may not be assigned without the written consent of all parties, except in connection with a tax-deferred exchange, which is next. But if assigned by agreement, then this contract shall be binding on the assignee and assignee's heirs and successors. So our offer to purchase and contract can be assigned as long as we have the written consent of all parties. And again, for an example of who might be doing this, I'm taking back to our wholesalers. It's this growing, it's this new age crop coming out of the real estate market. And like I said, the best way I've ever heard it described to me was just think about Costco. They buy bulk and they turn around and sell wholesale. So sometimes I've seen requests for assignments for the wholesaler. They want to go ahead and buy it and assign the contract to another party. All I'm going to do is present this to my generally seller, and if they have questions about it, then I need to make sure that they talk to their attorney before they agree to any assignments. Specifically, what kind of fees they may have, for example. And then we see a tax-deferred exchange. This is a program for investors through the IRS, a 1099 exchange or 1049, I don't remember now, doesn't matter, but it's a tax-deferred exchange to the IRS. And basically what the tax-deferred exchange will allow the investor buyer to do is sell an investment property and use the proceeds of that investment property to buy another investment property. And as long as they are exchanging investment property for investment property, then they can defer paying taxes, capital gains taxes on the investment property they just sold. And there's no end in sight of this. They can keep doing until they're done with the investment gain. If you're an investor or you're going to work with investors, I would recommend that you get with an accountant to make sure we understand the current tax deferred exchange programs, because there's rules. You have to buy something within X amount of time of selling and, you know, There's certain limitations and stuff. So the accountants can help with that. The contract says about a tax deferred exchange, in the event buyer or seller desires to effect a tax deferred exchange in connection with the conveyance of the property, buyer and seller agree to cooperate in effecting such exchange, provided, however, that the exchanging party shall be responsible for all additional costs associated with the exchange. Provide further that the non-exchanging party shall not assume any additional liability with respect to the exchange. Buyer and seller shall execute such additional documents, including assignment of this contract at no cost to the non-exchanging party, as shall be required to give effect to this provision. The parties to this contract, the parties shall be binding upon and shall, in order to the benefit of the buyer and the seller and their respective heirs, successors, and assigns. This contract is binding to the parties and their heirs. When do heirs kick in? When anybody passes away upon death. So the parties and their heirs. Words in the singular include the plural, masculine includes feminine, just making sure we have our neutral gender appropriate words. Survival. Any provision herein contained which by its nature and effect is required to be observed, kept, or performed after closing, it shall survive closing and remain binding upon and for the benefit of the parties. So there's a few things in the contract we saw that shall survive closing. Like, for example, if the seller, can't pass clear marketable title, their right to convey that, their right to clear up whatever on the title shall survive closing. If the buyer terminates and their agent damaged the property, their duty to repair shall survive the termination. So we have several references to the survival throughout the contract. That's just summing that up. Entire agreement, recordation. This contract contains the entire agreement of the parties. There are no other provisions other than those expressed herein. Changes, additions, or deletions must be in writing and signed by all parties. Nothing contained herein shall alter any agreement between a realtor or broker and seller or buyer as contained in the listing agreement, buyer's agency agreement, or other agency agreement. This agreement shall not be recorded without the express consent of buyer or seller. Contracts generally are not recorded, but if one party does want to record, then we got to get express written consent by both to record the contract. I'll tell you where this sentence came to be. I took a forms class with somebody that is on the forms committee. And again, around the pandemic, it was such a swift moving market. I mean, homes were staying on the market for like a couple hours. And buyers were really feeling the stress and the strain. And so some buyers were taking the contract and recording the contract, which then locked the sellers in. Because if the buyer terminated and another buyer went under contract and their attorney did the title search, you know what they're going to find? This recorded contract. So it slowed things down. It didn't deter second buyer from buying, but it did slow things down because we had to get that cleared up on the title before we could proceed. So they added that, just can't record the contract without express written consent by both parties.
And what was their reason for recording the contract?
Just to lock the sellers down, just to make the sellers mad because, buyers were so upset. It was such an unfair buyer's market. They were just petty, So you record now that I'm not going to buy your house, but guess what? Nobody is either. Ha, ha, ha. Yeah, just pure, I'm a jerk. I got to exercise my jerk. All right, conduct of transaction. The parties agree that any action between them relating to this transaction contemplated may be conducted by electronic means. So not only do we have the consent to use electronic means with our e-signature programs, but we also address it here in the contract that they agree we may use electronic means, including the signing of this contract by one or more of them and any notice or communication given in connection with the contract. Any written notice or communication may be transmitted to any mailing address, email, fax number, as set forth below in the notice information. Any notice or communication to be given to a party herein and any fee, deposit, or other payment may be given to the party or such party's agent. This is what gives us permission to deliver the due diligence and earnest money. Delivery of any notice to a party via means of electronic transmission shall be deemed complete at such time as the sender performs the final act and to send such transmission in a form capable of being processed by the receiving party system to any electronic address provided in the notice information below. Seller and buyer agree that the notice information and acknowledgement of receipt sections are not a material part of this contract, and that the addition or modification of that information shall not constitute a rejection of an offer or a creation of a counteroffer. What this last piece is saying, technically speaking, the last 2 pages of the contract are not part of the contract. They're just supplemental pages to help us with that information. So we'll see what I'm talking about in just one second. We'll see where the contract ends and what those last 2 pages are about. Execution, this contract can be signed in multiple originals or counterparts, all of which together constitute one and the same. Computation of days. The term days shall mean consecutive calendar days that do include Saturday, Sunday, and holidays. So when we're in contract world, a day is a day is a day. So counting the 7-day delay, counting the X amount of day of due diligence, a day is a day. For the purposes of calculating days, the count of days shall begin on the day following the day upon any which notice is provided. Any reference to a date and time is the date and time of North Carolina. In other words, Eastern Standard Time. I don't care where the people are, it's where the property is. That was an issue. I remember why that was added to the contract, because we had a buyer in California. Due diligence was ending. The buyer terminated within due diligence California time. And so now, because it became a thing, they added it to the contract, so we're all clear that when we say 5 p.m., that is Eastern Standard Time. And again, day is the day following any act or notice. So that 7-day delay, for example, if today's the day of settlement, we're 7-day delay, tomorrow's day 1 of the delay. I'm sorry, what is today? Is it still Tuesday?
And earlier was
Tuesday, so Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, Monday.
Today's Tuesday, so you don't count Tuesday.
Today is Tuesday. Is it not Monday? Dang it. So off. Whatever
it's
today
Wednesday.
is, tomorrow is the next day, right? I have no clue. I have a
Tomorrow's
count
day 1.
told me I was supposed to be here tonight. That's why I'm here. But yeah, the day after, day 1 is that day after.
what I was saying. You can't do anything on Saturday and Sunday.
Correct.
So if it's on Saturday or Sunday, there's nothing you could do anyway
Correct.
to correct the contractor. You're just out of luck. It just fell that way.
A day is a day.
Okay.
I mean, you can do something because
Yeah.
realtors and other people work on weekends, but attorneys don't to close. Neither do
Attorneys
the
don't,
bank.
yeah. So if your day 7 is a Saturday or Sunday or a holiday, you know you're not closing on that day. You know your day 7 will be when the attorney gets back. Communication with the other agent. I'm telling you guys, it'll solve a lot of uncertainties and confusions. And if we are going past that 7-day, if day 7 is a Saturday and we're all in agreement to go on Monday, then we need to do agreement to amend. We need to make sure that everybody is on paper agreeing to do those extra couple days.
Okay.
This explains where you said the confusion is with the days at the top of the for due diligence, but you still need to communicate. But
Yes.
it's right
Yes.
there.
What does the contract say? And I'd be willing to bet if you just had a conversation with, I mean, even seasoned agents, there are so many different ways that you can calculate days. You know, Jeffrey, I was a listing agent and they needed more time. I don't remember why. And they wanted X amount of day delay. I don't remember the specifics. It was so long ago, but he actually came back and argued with me. Well, we can't count New Year's Day because New Year's Day is a holiday. You know what I said? I said, what does the contract say? In contract world, does New Year's Day count? A day is a day is a day. And this was a seasoned agent arguing with me. And I don't know. What does the contract say? Be familiar with the contract, you guys. This is how we can best protect our buyers and sellers. Okay, remedies. Here's my thoughts on remedies before we look at this. Remedies, again, once upon a time ago, were scattered all over the contract. You could like piecemeal it and find it in several different places. Several years ago, they revamped it and they gave us remedies in one nice, neat package. So we have remedies breached by either party in one nice, neat little section. My only complaint is that they tacked it at the very end, where we tend not to pay attention to this last page anyway, and we tend to forget that it's here. So another reminder to review the contract periodically, because we do not do much with this last page. This is one of the pages that just gets glossed over. So remember that it's here. And if you do have a party in breach, this is where we start. So let's first start talking about the buyer's breach. And understand, the buyer's not in breach until after due diligence. The contract gives them the right to terminate for any reason or no reason until 5 p.m. on the due diligence date. So when we talk about buyer breach, it's at 5:01. Everybody with me so far? So in the event of material breach of this contract by the buyer, seller shall be entitled to the earnest money deposit. The payment of the earnest money deposit and the due diligence fee to the seller, without regard to their respective amounts, including zero, together shall serve as the seller's liquidated damages and as the seller's sole and exclusive remedy for such breach, providing that those liquidated damages shall not limit the seller's rights under paragraphs 4E and 4F above for damages to the properties, as well as seller's right to terminate under 1D for dishonored funds. It is acknowledged by the parties that the amount of the liquidated damages is compensatory, not punitive, such amount being a reasonable estimation of the actual loss that the seller would incur as a result of breach to this contract by buyer. The payment to the seller of liquidated damage shall not constitute a penalty or forfeiture, but actual compensation for seller's anticipated loss, both parties acknowledging the difficulty of determining seller's actual damages for such breach. Several things.
Okay.
Liquidated.
Can I ask a question real quick?
Sure.
What if they put in their due diligence and they put in earnest money? Let's use $1,000, okay? And they've got 10 days of due diligence. The 10 days is coming to an end, and the buyer asks for another 10 days and puts down another $1,000 of due diligence, just to add it in there. So now you got 2,000 and 1,000. So the due diligence, they're paying to look. I mean, for their time, they're paying for me to do this. So at the end of day 20, at this point, they decide I'm not going to go through with it. They would get the $1,000 back, right? And not the 2,000.
It's all due diligence fee, whether we pay it now or we agree to pay it later. Due diligence is going to stay with the seller unless there's 3 times we saw in the contract that the seller would have to give it back. Because that's what the buyer's paying for, is the right to terminate.
I went through that with selling a piece of my mom's property before I started studying this stuff, and they came back and wanted just a little bit more time. And so we told them we wanted more money on the table, and they did it.
That's a very common response. So all you've done is extended the time, extended the money. It's still due diligence fee. It's still the due diligence period.
But that
It's
kept,
still that.
they still could have backed. I see what they were doing now. You know, I didn't see it back then, but I do now.
Now you know. Yep. Yep. So liquidated damages we've defined. We talked about this back in chapter 10. And liquidated damages are money damages that we agree to up front at the time of contract formation. Remember page 1? Didn't we negotiate the earnest money deposit and the due diligence fee? So the earnest money deposit and the due diligence fee are defined as the seller's liquidated damages and as their sole and exclusive remedy. So the buyer that terminates, I remember my buyer that called me 3 hours before settlement and said, yeah, we're not buying. What did the seller get? Earnest money and due diligence. What else did the seller get? That's it. Sole and exclusive remedy. Listing agents. When that offer comes in, we need to make sure that the sellers are good with the earnest money deposit and the due diligence fee. They need to understand that if the buyer never shows up for settlement, if that buyer's in breach, this is all you get. As that pendulum starts swinging back to a buyer's market, we've been in a strong seller's market in the pandemic. Seller's market, we're still in a seller's market, not as strong. And one day we're going to see that pendulum swing back. And one day we'll be back in a buyer's market. And as we see this pendulum swinging, we're seeing due diligence and earnest monies come down. Remember the strong sellers market in the pandemic? It was like absurd amounts of money, 5-digit, 6-digit. Guess what? We're going to see the opposite of it when it comes back around. Now we're in a buyer's market. You might get an offer one day with $50 in due diligence, $50 in earnest money. You need to make sure that your sellers are good with that amount, and they need to understand what that amount is. This is it, guys. This is all you get. I think a common question what a lot of this is addressing, what if? All the what ifs in life, right? What if, as part of the terms of the contract, the seller agreed to a bunch of repairs? They actually agreed to fix this, this, and this. And now the buyer backs out 3 hours prior to settlement. Can the seller go after the buyer for those costs of repairs for the money they put in to fix the house? No. But when I put it back on the market, don't I have a better product? Can I put it on with a price improvement because this, and this have been addressed? Can't we let the next buyer know? Buyer terminated, electrical has been repaired, invoices available upon request. So we can't get the seller their money back from repairs for this buyer. But before we put it on the market, let's revisit that CMA. Let's make sure that we get a listing price and now reflect some of those repairs if they were worth something. Does that make sense? I'm putting a better product on the market than what I had before. So breach by buyer, all the seller gets, sole and exclusive remedy. And your seller's going to look at you and say, well, I'm going to sue the buyer. I'm going to take them to court. Okay. The judge is going to pick up the contract and he's going to read that. What is it you want, Mr. Seller? Because you agreed with those liquidated damages were your sole and exclusive remedy. Then we got breached by the seller. In the event of breach of this contract by the seller, once again, our buyer has choices. They can terminate this contract as a result of such breach and shall be entitled to the return of both the earnest money and the due diligence, together with the reasonable costs actually incurred by buyer in connection with their due diligence. If the seller breaches, may this be on day 1 or may this be the day of settlement, the seller doesn't have an easy exit. They don't have an out. So if the seller terminates for any reason they're in breach, the buyer's got 2 choices. They either terminate and go after their monies, or they elect not to terminate treat this contract as remaining in full force and go after the remedy of specific performance. Their first option, collect their monies. That's what we refer to as the buyer's compensatory damages. We're trying to make the injured party whole. I reimburse you your due diligence fee, your earnest money deposit, plus the seller gives you what you paid for the cost of the appraisal, the home inspection, the pest inspection, the survey, all that stuff that you paid for, all falls under that due diligence costs. If the seller's not willing to sit down and write out a check, then the buyer may have to take them to court.
Can
So
we
either,
negotiate that? Like, can we, if the seller is in breach and we're the buyer's agent, can we say, okay, we need our due diligence, you know, contact the listing agent and say, we're owed due diligence, earnest money, and here's the bill, or here's the receipts or whatever to make them whole again.
yep.
Okay. So they
All
don't
you're
have to
doing
go
is
to
just
court for that.
reiterating what the contract says. So you know how much you spend in due diligence. You know how much we spent out earnest money. Here's the invoices for everything else that they've spent for those due diligence costs. Like I said, if they're not willing to sit down and write a check, your buyer's going to look at you and say, well, what do I do? We say, talk to your attorney. Or they don't terminate. They keep this contract as remaining in full force, and now they're going after specific performance. Remember, with specific performance, the injured party is trying to make the other party perform as promised. For here, there's a difference in the seller that won't perform versus the seller that can't perform. What if we find out after contract formation that the seller owes money? And furthermore, the seller says they don't have the money to sell. Can you make them come up with the money? Can you make them just poof and manifest the money from somewhere? See why we're having this conversation when we list it as opposed to contract formation. But if they can't, maybe there's a spouse that won't come sign the deed. You know, they can't convey. So I think with specific performance, again, there's a difference in won't sell versus can't sell. Can we agree, even though bigger, can we agree that the remedies for breach by the seller are much harsher than remedies for breach by the buyer? I mean, so the buyer breaches in G, they just lose earnest money and due diligence. The seller breaches and the buyer can sue the pants off them, can't they? They can make a decision and they can go after court and they can sue the pants off them. This was designed this way. And the reason being why the remedies for breach by seller are much harsher is because the seller is the one that initiated this whole thing to begin with by putting a for sale sign in their yard, by inviting a buyer to bring them an offer. If they didn't want to sell or couldn't sell, then they shouldn't have made the offer to sell. So if your seller's going to change their mind, it's not going to be about this contract. That's the thing with the seller. When they're in without legal ramifications. Attorney's fees. If legal proceedings are brought by buyer or seller against the other to collect earnest money deposit, due diligence fee, or due diligence costs, the parties agree that the parties shall be entitled to recover reasonable attorney fees to the extent permitted under these North Carolina general statutes for dishonored funds. The parties acknowledge and agree that the terms of this contract with respect to the entitlement of the earnest money, due diligence fee, or due diligence costs each constitute an evidence of indebtedness pursuant to this North Carolina general statute. In other words, you guys, let's just say, for example, that the seller's in breach, the seller's the breaching party, and the buyer's going after the money. I want the due diligence fee, the deposit, and the due diligence costs. And the seller says, nope, not going to do it. Not going to cut you a check. Just not going to do it. You as the listing agent, you sit down with your seller, you read this paragraph to them, you tell them what it says, and they say, no, I'm not going to do it. Buyer takes the seller to court. And you know what this paragraph says? Not only is the seller going to lose, because what does the contract say? Not only are they going to lose and be responsible for their attorney's fees, but guess what? They're going to also get to pay the buyer's attorney's fees. So when you have that stubborn seller or buyer that's not willing to cooperate, not willing to sign, give them a day or two to simmer down and make sure they understand if this goes that far and you're the losing party, you're the breaching party, you're not only going to pay what the contract says you're going to pay, you're going to pay your attorney's fees and you're going to pay the other guy's attorney's fees as well. Is it fair? But what does the contract say? Remedies for breach, number 23. They've done a very nice job of consolidating it all in one place. Just please, please, please don't forget that it's tacked on at the very end where we don't ever see it. It's here. We just need to be reminded that it's here. Questions or comments on this paragraph? Blue note, parties seeking recovery of attorney's fees under this North Carolina general statute must first give written notice to the other party that they have 5 days from the mailing of the notice to pay the outstanding amount without the attorney's fees. And again, if I were the agent and I was here, I would literally copy and paste this general statute into Google and see what this actually says, because this is what this is doing. It's referencing this specific state law. This one always makes me laugh. You know, the creators of this form? North Carolina Association of Realtors and the North Carolina Bar Association make no representation as to the legal validity or adequacy of any provision of this form in any specific transaction. If you do not understand this form or feel that it does not provide for your legal needs, you should consult with an attorney before you sign it. They can't vouch for every transaction. They can't vouch for every specific sale. And they're letting you know that if this doesn't fit your needs, if this doesn't work for you, you need to sign, you need to talk to your attorney, not after you sign it, but before you sign it. Because once you sign and we have communication of acceptance, whether you like it or not, folks, you're legally bound to this contract.
It's their hold harmless.
It's their hold harmless. It's exactly what it is. This offer shall become a binding contract on the effective date. Remember, we defined that effective date in the first terms and definitions. Unless specifically provided otherwise, buyer's failure to timely deliver any fee, deposit, or any payment provided for herein shall not prevent this offer from becoming a binding contract, provided that any such failure shall give seller certain rights to terminate the contract as described herein, or is otherwise permitted by law. And then I got a place, buyer sign on the left, seller sign on the right. I got a place for 2 individual buyers, 2 individual sellers. If you're working with an LLC or a corporation, then you're going to use the entity buyer, entity seller, and they have one person that's allowed to sign on their behalf. The entity can't sign. So they have a person that can sign on their behalf. If you have more than 2 buyers or you have more than 2 sellers, I got a form for that. Yep. Kara knows the answer. We got a form for that. And I'm not going to spend a lot of time on it, but just because we mentioned it, it's something called the additional signatures addendum. And as you can see, I can use this. I'm going to list what all this applies to, what all documents. I mean, this is going to start with the listing agreement, the listing paperwork. We'll use it again for the contract paperwork. Whenever you have more than two, I need everybody to sign. So the additional signatures addendum, and we got a place for what? 1, 2, 3, 4, 5, 6, 7 more people, or a separate, 2 more separate entities. So I have 2 signing the contract. I have 7 more on here, so I have 9. What if I need more than 9? Then I use another additional signatures addenda. And I use as many of these as I need to make sure that I have all parties sign from day one when we sign that agency agreement.
Do you need one per document? So like if you have, or can you just list all the documents that it applies to? Okay.
Yep. So I could say like 101 listing agreement, RPOs, MOG, working with real estate agent, right? Everything I need for the listing paperwork, I could just use this one. Now, fast forward and we go under contract. So I could list out offer to purchase and contract, FHA, VA financing addenda, right? So you may use this several times, but it'd be through different stages, different phases of the transaction. So where the parties sign is technically where the contract ends. It's the last piece of the contract to have everybody's signature, which is what that other paragraph was talking about. The last 3 pages, actually, 15, 16, and 17, are not part of the binding contract. They're just here to help us with the rest of it. So the contract actually ends on 14 pages. I know I keep saying this thing is 17 pages long, but really it's only 14 pages. I got a page with a wire fraud warning. Wire fraud's one of those things that's gotten really big, really fast in real estate. Y'all think about the billions of dollars that change hands every year through real estate transactions across this country. And we figured out we can do this electronically. Buyers can pay their closing attorneys electronically. Closing attorneys can pay the sellers their proceeds electronically. So the electronic world is grown. It's here and it's in real estate. And we all know how hackers work, right? This is like the dream for them. You could get one buyer's wire transfer, or you could intercept one seller's proceeds transfer. And that's a great payday, isn't it? That's a great payoff for the hacker. So we need to make sure that we're having conversations with our buyers and sellers about the risks of wire transfer. Specifically what this is addressing, and you guys can find this even in our agency agreements. So we're mentioning it to both parties throughout the transaction. Bottom line, you guys, you need to look your buyers and sellers in the eyeball and tell them, do not send an electronic transfer, a wire transfer to an attorney based on any information you get in an email. Even if it looks like it's from me or it looks like it's from the attorney, don't trust emails. Emails are easily hackable. They're not secured. You know, think about your Gmail email. That thing's about as secure as my closet door. So what they want to do instead is go old school, pick up the phone and call the closing attorney and make those wire transfer instructions over the phone. And by the way, when they're calling the attorney, they're calling on a number that you gave them or that they looked up. Don't have them call a number in an email, because now you got them calling the hackers. So we need to independently get the number of the attorney's office. You and I do not need to be involved in this conversation. This is one place that we can let our clients talk directly to the attorney and let them exchange wire transfer information over the phone. Thoughts on that? It's big. for you guys, you can also not only protect your clients' confidential sensitive information, but yours as well. So if you want to go work one afternoon at Starbucks, get you a little treat and find a little corner, sit down to work, I think that's great. Do it. It gets you away from your desk every once in a while. But when you go to Starbucks, don't jump on their public Wi-Fi. Do you know who can access the public Wi-Fi? The public. So don't, y'all, I had to go to Discount Tire this morning. I had a leak in one of my tires, son of a gun, and I had to go to Discount Tire. And I had too much to do to go to Discount Tire this morning. So I grabbed my laptop and I went to Discount Tire. And I sat in Discount Tire and did what I had to do on my mobile hotspot. I did not get my laptop on Discount Tire's public Wi-Fi. I jumped on my mobile hotspot to keep that secure while I was hanging out at Discount Tire. Keep your information secure. Keep your information protected. And I'll leave you with this. It had to have been 2019. It was right before the pandemic. And there was a wire fraud seminar going around the state of North Carolina. The North Carolina Real Estate Commission, the North Carolina Bar Association, the FBI, a title insurance company, and maybe somebody else was there, put on this seminar. And they offered it in Raleigh. So Lane and I did a little road trip and went down to Raleigh for the day. And it just blew my mind, the things I heard that day. The FBI stood there and looked at us and said, hackers are always 1 to 2 steps ahead of us. Just when we figure out where they are and what they're doing, they've moved on to the next. That's how they keep going, because they can't get caught up with. They can't be caught up with. We've got to make sure we're protecting our buyers and sellers at all costs. And again, that includes with their confidential information, with their money, and just making sure that they're not relying on an email. Another page of the contract that's not part of the contract is the notice information. So we got a blue note that's telling us to insert at least one address and or electronic delivery address each party and agent approves for the receipt of any notice contemplated by this contract. Insert NA for any which are not approved. And then we have a place where you put in the buyer notice address and the seller notice address. Get with your BIC. Some BICs want you filling this out. Other BICs are saying, no, don't give our clients information to the other side. What I'm telling you is get with your BIC. After that, then we have our notice information, and this does need to be complete. This does need to be filled out. There's a commission rule that says that we've got to address who the selling agent firm are and who the listing agent firm are. So confirmation of agency, it gives us the opportunity to disclose my role, as well as give notice information how I want to be communicated with throughout this transaction. Buyers on the left. So we got the selling firm name, and then the role of the selling firm. Is the selling firm acting as a buyer's agent, a seller sub-agent, or a dual agent? License number of the firm. And then we're going to list the individual selling agent. Check this box if you're acting as a designated dual agent. There's your license number, phone, fax, email. Then we go through that same little exercise on the right. Listing firm and what their role is. Is the listing firm acting as a selling agent or a dual agent with everybody's contact information? So your BIC may say, no, don't fill out this top part. Commission rule says we need to at least do this, and how you want to communicate with that other agent throughout this transaction. And then the last page of the contract, it's not part of the contract, is the acknowledgement of receipt of monies. So as our due diligence fee changes hands, the parties need to acknowledge receipt of it. When the earnest money deposit changes hands, the parties need to acknowledge receipt of it. And you'll notice, just FYI, I have a place for the buyer and seller, of course, but I also have a place for the property address, because this page is happening after contract formation, and often it gets separated from the contract. So we want to make sure that we're all on the same piece, on the same board what this page is for: seller, buyer, property address. The listing agent is going to sign acknowledging receipt of the due diligence fee, or the listing firm will sign acknowledging. Again, your firm may have a policy, but somebody from the listing firm is going to sign acknowledge receipt. Listing agents, can we all agree that in your hand and on its way are two totally different things? Please don't sign this until it's in your hand. Sometimes they'll call you and say, well, I'm going to drop it off after lunch, so just go ahead and leave me the signed acknowledgement at the front desk so I can pick it up when I get there. Can a lot happen between now and after lunch? Yeah. So again, don't sign for it until you have it. There have been cases where the due diligence fee has gone missing, and the commission investigates on behalf of the seller, and they get their hands on this page where the listing agent signs for it. Well, I didn't get it. Then why did you sign that you acknowledge receipt of it? So just make sure you're good there. Listing agents, once you have it, the next thing you're going to do is deliver it to your seller and have your seller sign acknowledging that they've received it. Escrow agents are going to sign acknowledging that they've received the initial earnest money, if any. They're going to sign acknowledging the additional earnest money, if any. And you will note too, earnest money is additional earnest money is a time is of the essence. So in addition to what date did you drop off the additional earnest money, we also need the escrow agent to acknowledge what time it was to make sure we're within that time is of the essence.
Are we actually like cutting these off and like using them as a receipt, or is this just like
one page? I know that dotted line looks weird, right? But we're usually just seeing this as one page.
okay? I was like,
And yeah,
my thought is cut like making a receipt.
yeah, no, I hear you. And look, there's no wrong way to do it. I've seen them where the listing agent signed this copy, the seller signed this copy, maybe the escrow agent signed another copy, right? So I don't have to have it all together, because everything is referencing this seller, this buyer, and this property address. So again, just making sure that we're all, then again, I have agents that won't do it if they can't get all signatures on one page, you know, so there's no wrong way to do it. We're all referencing that same fees. That's it, folks. That's your 17-page offer to purchase and contract.
Gabe just died.
He conked out, you know, it's a lot. Can we agree with that? There's a lot of information in here. There's a lot of good information in here.
We're
There's
many,
what we need to be able to do our jobs.
many lawyers. We're lawyers.
Lots of lawyers involved. Court cases, disciplinary actions, right? I think I told you guys this last week, but you know, I bought my little condo in 2006. So that was what, 19 years ago? 19 years ago, this thing was like 7 or 8 pages long. So we've gained, you know, 19 years ago, due diligence didn't exist in North Carolina. Things are going to continue to change and grow. If you're a person that doesn't like change, I wish you would have thought about that before you got into real estate, because we we love our change. I have heard the Forms Committee has mentioned that there's going to be a revised offer to purchase contract come out this July. I don't know specifics yet, doesn't matter yet. We'll get to it in July. I just say that for you guys to know. Pay attention to your emails, pay attention to your firm. Your firm may have a sales meeting on the contracts, on the changes and what you need to know. So just stay current, stay on top of the current information. Yeah.
I have a question on I was doing a learn test pass question and I got it wrong and I don't like the answer.
Do you have the
So
question?
yeah, I was just pulling it up.
Can you
okay.
screenshot it and send it to me? I got to see it. If you still have it.
I don't know how to screenshot on my computer. I will figure that out and get it to you.
And I just say that because if you have a concern about it being right, I want to see it, but I need to see it. And that's just how my brain works. So even take a picture with your phone. There you go. And
I
text
can
it
take a
to me.
picture of my phone and then
And I'll definitely get that addressed. But yeah, any questions like that, Learn Test Pass. I know so many times, especially pre-licensing, they'll come to me and say, well, the question said something along the lines of, but going through it, that every one word can change the meaning of the whole thing. And if I don't see all the words, then I'm not going to be able to properly answer that question. Kara, I'm sorry about that, but that's
yeah,
just easier.
I think I just figured it out. Never mind. I read the one word.
That one word.
That one word, which is false.
Even
Yeah.
better. So
Okay.
yeah, that was easy.
Yeah. Yeah. I was like, that's not right. I was like, it's not the correct answer was it's the only contract they can use. And I was like, that's not the only contract that they can use. But
My gosh, I think I got the same one wrong as you. That sounds very familiar. There, I remember doing a learn test pass. Pretty sure it was a true or false, and there was one very important little word in there that they added, and I got it wrong. As soon as I saw it, I was like, "Oh, yeah, there it is." So yeah,
You guys know that
that
coming out of
happens.
training. I'm not making this stuff up. You guys know that, so you got to pay
I was
attention.
doing
Read the
multiple things at the
words.
same time,
For
so that's
sure.
probably why.
Yep. Yep. So that's our I mean that's 2T. It's a lot to take in. Like I said, we'll do a review on Thursday because there's what we need to know in the real world, and then of course we want to hone in just to know for the exam. So I'm not doing the review first because that's all you guys would care about. So we're going through the whole thing and then helping you know what it is we need to focus on for that test. So we'll revisit what we need to from 2T. Tomorrow night, more fun with forms. Tonight was like fun with form. So tomorrow night is going to be like fun with forms. And we're going to look at some of those commonly used addenda that we've been talking about specifically about what they do. And we got the end in sight. So, a little bit more to wrap up on Thursday, but we're doing really good. Most of Thursday is going to be set aside for a review. So not only the material, but also don't forget in your Google Drive, you have there you go. You have closing problem 2. And there's two in Learn Test Pass. So that's why I put this one here so we make sure we're doing the right number 2, the right closing problem 2. And we'll go through that on Thursday as well.
The one I was doing on Learn Test Pass was I compared it, I think, on when I had the break, and I compared it, and it was the same one, but it was that one has the full statement versus the one that I saw or that I was doing from Learn Test Pass was like sections of it, and then it was showing you how to do it.
I gotcha. That's good to know, Kara. Thank you. Yeah.
Yeah.
Because some of you may want to walk through step by step like Learn Test Pass has you do, but others may just want to jump in and do it. So there's something for everybody, right? However you learn best.
All right. Thank you.
What else? We good? Is that it? Let's call it. Good night, you guys. See you tomorrow.
Have a good day.
Good night. Have a good day tomorrow. Stay dry.
Rain.
All that rain.
Had enough. All righty. Well, you take care.
Good night. Thank you. You too.
Yes, ma'am. Bye.